Yes. Honorable members, good morning. Good morning, and can we take this opportunity to request everybody to take their seats? We are at 9 o'clock. We must start with today's business. I want to take this opportunity to greet you, all of you, starting with the members of the ad hoc committee, our legal team, the support staff of Parliament, and all South Africans who are with us here or are watching the proceedings on television. The members of the media who are with us here, Lieutenant General Mkhwanazi, greetings to you and welcome. My name is Molapi Soviet Lachanyana. I'm the chairperson of this ad hoc committee, which comprises 11 members, 4 from the African National Congress, 2 from the Mkondo Wesizwe Party, 2 from the Democratic Alliance, 1 from the EFF, 1 from the IFP, and 1 from the Patriotic Alliance. From the African National Congress, we have the Chief Whip, Honorable Ntuli. Honorable member, if you may please just wave so that people can identify you. And then we thank you so much. We have Honorable Sangoni K. We have Honorable Ngola. And then from the MKP, we have Honorable Skosana. Honorable Skosana, thank you so much. Honorable Nombalo. From the Democratic Alliance, we have Honorable Ian Cameron and Honorable Breitenbach. Yes, no, it's okay. Yeah, the member of this committee from the Democratic Alliance is Honorable Breitenbach. I'll explain that later. And from the EFF, we have Honorable Malema JS. And then from the IFP, we have Honorable Mwango. From the Patriotic Alliance, we have Honorable Sols. And then we have alternate members. Alternate members are those members who participate in the committee activities in the event the full member is unable to come or is unavailable. So the alternate member from the African National Congress is Honorable Sokanyile. And then the alternate member from the MKP is Honorable Shongwe. He should be coming, he will join us later. And the member who is arriving now is Honorable Sols. We have just introduced you, Honorable Member. And then from the Democratic Alliance, the alternate member is Honorable Dian Kwalabanat, who is here with us. And then from the, and Honorable Shikeleng is also here from the Democratic Alliance. And then we have from the EFF, Honorable Leanne Matthews, who is the alternate member. Leanne Matthews, who is the alternate member. Pardon me, Honorable Matthews, for saying Matthews. And then we have two more alternate members for the IFP and the Patriotic Alliance, which we call the minority parties. And the alternate members, unlike the other parties that I have mentioned, names of alternate members coming from the same parties. With the IFP and the Patriotic Alliance, the alternate members are coming from other minority parties. That will be Honorable Vessels from the Freedom Front Plus and Honorable James from Action SA. Am I seeing Honorable James here? Thank you so much. Yeah, I wanted to be certain that you are here and South Africans see that you are here. There are two more honorable members that I'm seeing, one from the EFF and one from the DA. We want to thank you for your presence, Doctor. You can just and Honorable Pambo, thank you so much. Thank you so much for your presence here. I think there is no more members that I would have not acknowledged. If there is you can just alert me and then I duly recognize your presence. Thank you so much. Then our legal team is led by Senior Counsel Advocate Norman Arendse. Thank you so much, Honorable Arendse. He is also our Chief Evidence Leader. And then the core evidence leaders are Lerato Zikalala and Maria Mkhwanazi. Thank you so much. Proud to have you here, women of South Africa. Can you once again raise your hands? Thank you so much. We have Andile Tejana from Parliament Legal Services. And then there are two gentlemen doing secretarial duties sitting here with me. If you don't see them, they will come to join me. It's Bonani Ramano and Pilot Kwebu. And then our witness, the first witness that the committee has agreed on, has arrived here. We take this opportunity to welcome you, Lieutenant General Nhlanhla Mkhwanazi, the Provincial Commissioner for the KwaZulu-Natal province. Welcome here. Honorable members and everyone from Parliament, staff, from the media, we once again welcome you. It is time that we should start with the proceedings. I think I'm done with the introductions. I'm now going to request the Senior Counsel, Advocate Arendse, to come and make an opening statement.
Thank you, Honorable Chair. Can you hear me? Honorable Chair, honorable members, my colleagues, members of the parliamentary legal team, and everybody who has more than ably assisted us in getting to this point where we can now commence these proceedings. Also, thank you to Lieutenant General Mkhwanazi and all the other witnesses that we have interviewed and taken statements from for their voluntary cooperation and willingness to meet at our request, which has facilitated us to get to a point of readiness today. If I may make an opening statement on behalf of the evidence leaders, Honorable Chair. It is often said that success should be the natural reward for hard work, initiative, and moral uprightness. The opposite can also be true, and such is the urgency of the challenge we face. We need a collective sense of mission to change mindsets and to steer the nation away from a dangerous course. Just as we extricated South Africa from the mire of conflict, we are now called upon to use new tools at our disposal to build a prosperous, truly just, and morally upright nation. Democracy has taken root in our country and in our region, and we have peace and political stability. But all this will be little more than the shifting sands of illusion if we do not take decisive measures to strengthen the moral fiber of our nation. In this context, it is legitimate for us to examine the root causes of crime and corruption, the poverty that stares us in the face, the illegitimacy of the previous order which elevated lawlessness into an honorable deed, the sanctions era which made underhand dealings a glorified national pastime, and the low pay and repressive focus in the security and other public services which turned upon their head the moral standards that these institutions are supposed to uphold. It is legitimate to argue that it will take much time and effort to change all this, that to heal the wound of moral decay will need patience and forbearance. Yet, this should not result in our being incapacitated. It should not postpone the concrete steps against crime and corruption which we need to take. Now, Honorable Chair and Honorable Members, you might think, wow, Arendse SC has penned these really poignant and entirely appropriate words. But I'm quoting to you from an opening address which was made by our founding President Mandela at the Business Initiative Against Corruption and Crime Conference just over 30 years ago. 30 years ago on the 19th of August, 1995. Honorable Chair and honorable members of this committee, since our past President's speech in 1995, we have failed to heal the wounds he refers to, and our fight against corruption has floundered. Various attempts have been made to address the scourge of corruption, and most notably the Commission of Inquiry into State Capture, the so-called Zondo Commission, which was established by the President to address what was described as state capture. The Commission's detailed reports records the mechanism used to capture the state. Placements of politically connected individuals were used to control and manipulate public procurement, financial and contracting processes in SOEs and the public sector for private gain. This strategy was bolstered by the appointment of individuals in positions of power in law enforcement and tax administration. We also had the Nugent Commission to ensure that perpetrators were protected. This breach Section 195 of the Constitution, which requires public administration that is ethical, professional, effective, impartial, and developmental. lack of compliance, transparency, and accountability in appointments of board members and senior executive enabled state capture. Honourable members, today we again convene at a critical juncture in our democracy as we consider the serious allegations placed before this honourable committee, which strikes at the heart of our democracy. On the 6th of July this year, 2025, Lieutenant General Nhlanhla Mkhwanazi, the Provincial Commissioner of Police in KwaZulu-Natal, publicly revealed the potential existence and operation of a sophisticated crime syndicate that has allegedly infiltrated law enforcement and intelligence structures within the Republic. These allegations demand a thorough and unflinching examination. Indeed, General Mkhwanazi has alleged political interference in the attempted disestablishment of the political killings task team, suggesting or alleging that there was a deliberate undermining of efforts to combat serious crime, in particular corruption. He alleged a potentially corrupt relationship between certain individuals and the Minister of Police, alleging collusion with organized drug cartels, and that these cartels exert undue influence over politicians and law enforcement officials within the South African Police Service, Metro Police, Correctional Services, the National Prosecuting Authority, the judiciary, and even members of the business community. The National Assembly, quite rightly, recognized these allegations of systemic corruption that has led to an erosion of public trust, and accordingly, it established this ad hoc committee in terms of Rule 253 of the Rules of the National Assembly to investigate these allegations fully and to report back to the National Assembly with recommendations to strengthen our institutions to prevent further abuse. Whilst the President has also taken these allegations seriously and appointed what is now known as the Nhlanhla Commission, this ad hoc committee focus addresses specific areas defined by its terms of reference, namely to investigate potential political interference, interrogating potentially corrupt relationships involving Minister Mchunu, Brown Mokgotsi, and Vusimuzi Kat Matlala, examining possible procurement irregularities within SAPS, and in particular, the 360 million rand SAPS healthcare contract with Medicare 24 Tswane, their role therein of Kat Matlala, assessing prosecutorial conduct, focusing on the investigating Directorate Against Corruption, IDAC, and whether its officials unlawfully interfered with police investigations or exceeded their mandate, probing the alleged existence of an organized crime syndicate controlled by drug cartels and its alleged infiltration of key criminal justice system role players, looking at the conduct of members of parliament with regard to classified information and potential links to criminal syndicates. Our inquiry must also consider whether Parliament's own oversight mechanisms have been effective in addressing these issues. Not only is this committee required to analyze and diagnose the problems and the causes of those problems, and whether indeed they are systemic, but also to propose forward-looking measures to strengthen the interagency coordination within the criminal justice system. This committee has a constitutional duty enshrined in a constitution to represent the people and to ensure government by the people. It must exercise its power to scrutinize and oversee executive action with diligence and impartiality. Its proceedings must conform to the fundamental principles of the rule of law, legality, rationality, procedural fairness, and justice required by its terms of reference. Ultimately, this committee's task is not merely to conduct an investigation. It must safeguard the integrity of our institutions, to restore public confidence and trust, and to uphold the principles of justice and the rule of law, which is foundational to our Constitution. To that end, we will be guided by the evidence of the so-called, or we call them the SAP, South African Police Service witnesses, in particular General Mkhwanazi, and General Masemola, the National Commissioner, the ministerial witnesses, Minister Mkhunu, former Minister Pele, and current Acting Minister Kachalia, and other witnesses. We remain committed to transparency, unwavering in our pursuit of the truth. We will call General Mkhwanazi and National Commissioner Masemola on the one end, and Minister Mkhunu and General Sabia on the other. We will also call from former Minister Pele, Acting Minister Kachalia, as well as Deputy Ministers Matali and Boshiela. These witnesses will be called during the first phase of this hearing. The committee will decide and identify witnesses to be called in the second phase of these hearings. In regard to the evidence given by the witnesses, we draw attention to Section 16 of the Powers and Privileges Act, which requires witnesses called before the committee to answer fully and satisfactorily to all questions lawfully put to them, to produce any document they are required to produce, notwithstanding that the answer to any question or the document could incriminate them or expose them to criminal or civil proceedings or damages. Witnesses are, however, protected in that the evidence given under oath or affirmation before this committee may not be used against any witness in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Thank you very much, Honourable Chair, Honourable Members. That's our opening statement. Could I now call General Mkhwanazi as our first witness and ask the Honourable Chair to administer the oath?
Chair.
Honourable Malema.
Thank you very much, Chairperson. And good morning, colleagues and General. I don't understand on which basis do you want General Mkhwanazi to take an oath? Because before us, we have no statement of General Mkhwanazi. We have a supplementary statement. Supplementing what? Because he must first depose to us a statement, and if there is anything to be supplemented, it should be done so. The statement we have is a statement disposed to the Commission. We have said to this legal team here, time and again, that we are not a junior committee of the Commission. There is no statement of General Mkhwanazi before us. There is a statement of General Mkhwanazi to the Commission. And therefore, in the absence of his statement to the ad hoc committee of Parliament, on which basis do you want him to take an oath? You should know, Chair, that a supplementary statement should be supplementing the original affidavit, if you wish to say so. There is no such. And therefore, General Mkhwanazi is not proper before us. And this legal team has failed us because in the deliberation, we made it very clear, if colleagues are honest with each other, we repeatedly said we cannot use the statement of the Commission. We are not a junior of the Commission. We have nothing to do with what the Commission is doing. We are a Parliament, a committee of Parliament. Now you want to use a material that is being used and sourced by a commission established by the executive in this separate arm of the state. It is wrong, it is unconstitutional. We have to do things properly. And the proper way is, there must be an original statement to us as an ad hoc committee. And if they so wish to be a supplementary statement, let it be. I even said, it doesn't matter, Chair, in that meeting. I said, we can even say to General Mkhwanazi, the first pages of that commission statement, where the statement is directed to a commission, they can be amended to say the ad hoc committee of parliament. And we have something that is directed to us, which will become our property, which will go into the archives of parliament as General Mkhwanazi's statement to parliament. In the history of this parliament, when our children and grandchildren and children of children are going to be looking for General Mkhwanazi's statement to parliament, they won't find it in the archives. So it's not proper before us. And the legal team is to be blamed, not himself. Thanks.
Advocate Arendse, can you please clarify that aspect?
Thank you, Honorable Chair, and in response to Honorable Malema. There is, with respect, a statement before this committee. The statement has now been sworn by General Mkhwanazi. We call it a supplementary statement because much of the factual background was covered extensively by the evidence leaders in the Nhlanhla Commission of Inquiry, and that is the 3 volumes you have before you, or 3.1 and 3.2, which contains General Mkhwanazi's statement and the annexes to that statement. At the Nhlanhla Commission, General Mkhwanazi gave evidence under oath, although his statement was not declared under oath. Judge Nhlanhla administered the oath, and he gave his evidence under oath. And it would therefore be quite surprising that his evidence before us today would differ materially from the evidence that he has already given before the Nhlanhla Commission. I acknowledge what Honorable Malema is saying about us not playing second fiddle to the Commission, as it were. But the fact of the matter is this. After Parliament decided to appoint this ad hoc committee and the appointment of ourselves was finalized, the Nhlanhla Commission had also been proclaimed by the President, and their evidence leaders got hold of Mkhwanazi first, and they started to take a statement from him, which they did, I think, General Mkhwanazi, over a period of some 2 weeks. You will recall, Honorable Chair, that I engaged with the evidence leaders for the Nhlanhla Commission. You engaged with the chairperson, Justice Nhlanhla, in relation to when General Mkhwanazi could become available to us. Given your terms of reference, you will recall this committee insisted that this hearing can only commence by us calling General Mkhwanazi first. So for a period of some 3 weeks or more, we were constrained or prevented from engaging with General Mkhwanazi to take a statement from him because he was unavailable. He explained his unavailability to you, Honorable Chair, and to the committee, and asked to be excused. As soon as he concluded his evidence before the Nhlanhla Commission, he indicated to us that he was now available to be consulted, and which we've done. Our consultation covers the evidence and the statement that he gave at the Nhlanhla Commission. We've attempted in this supplementary statement to avoid repetition. much of what General Mkhwanazi has been heard by honorable members of this committee, by members of the public and the media. In fact, his statement was his redacted statement was also made available to the media. So that is the approach that we've adopted, Honorable Chair, to this inquiry. What honorable members, Honorable Chair, what you will find different to what was done in the Nhlanhla Commission is that there'll be a lot more engagement with General Mkhwanazi in relation to the issues that forms part of the terms of reference of this committee and not necessarily before the Nhlanhla Commission. So General Mkhwanazi has been alerted to that, and we've consulted him about it. And different versions will be put to him as opposed to what was the case at the Nhlanhla Commission. So it is not only appropriate but necessary that we've incorporated the Nhlanhla statement as part of his statement before this committee, so that the record will indeed in years to come show that incorporated as part of General Mkhwanazi's statement to this committee is also the statement that he made to the Nhlanhla Commission. Thank you, Chair.
No, before I take the hands, I think what the honorable member wants to know is whether the sole statement that General Mkhwanazi made at the Nhlanhla Commission, does it enjoy precedence over this? Because the understanding is that it is supposed to be an annexure to the statement that he has made with yourselves.
No, Honorable Chair. This statement enjoys precedence, but it incorporates by reference the Nhlanhla Commission inquiry, and there are aspects in this statement where we will cross-reference what he said in the Nhlanhla.
I hear what you are saying. What he's trying to say is that we have two institutions of government, Parliament and the Executive. And then Parliament has appointed an ad hoc committee. We have more or less a common list of witnesses. So when a witness comes here, a witness deposits a sworn statement to us in accordance with our terms of reference. And then when we come to the proceedings, we then say, this witness who is appearing before us has also appeared elsewhere. Your statement as the ad hoc committee is this one, but for ease of understanding, there is this other statement which you would have deposited elsewhere. For the interest of members, you can also read it. It's not compulsory. But if you want to enrich your understanding, you can also read this other statement. That is what the honorable member wants to know. And his problem is that the word supplementary is used when this statement is supposed to be an original statement before Parliament, because it is not a document of another arm of government. It's a document of this arm of government, which is Parliament. So what we then have to understand between yourself and General Mkhwanazi is the ownership of this document. That this is the document which I myself as General Mkhwanazi had deposited before you as Parliament. And for the purpose of these proceedings, I can confirm that, yes, this is the statement I made with yourselves. If there is any other statement made elsewhere, you can also go through it, it's available. But for the purpose of these proceedings, I confirm that the document before you is the document that I deposited with yourselves. Can we have that understanding?
Well, there's no better person to answer that, Honorable Chair, than General Mkhwanazi himself. He can, hence I asked you if you to administer the oath. I will ask him whether this is an original statement that is made to this body.
Yes, let me take the hands. Before I take you, Oscar, let me go back to Honorable Malema, because he's the one who raised this point. He may want to make follow-ups, and then the list will be in this order. It will be Honorable Malema, it will be Honorable Skosana, Honorable Nombalo, Honorable Nhlanhla, and then Honorable Mwango.
No, thanks, Chair. I think the evidence leader, and this is so unfair on General Mkhwanazi. If we had a way, we should have just asked him to step out so that we can debate this. The senior counsel can't say that. Can't say the first statement to us is supplementary statement. That coming from a senior counsel. That the first statement you make is called supplementary statement. What law are you teaching people? It's unacceptable, and we can't help them, Chair, to cure it here in front of cameras. He has to go back and do the right thing. Because even if General Mkhwanazi says, this is my statement to Parliament, but what is written on this thing is supplementary statement. You can't change it. It's here before us. You are going to call General Mkhwanazi before this committee without an original statement. Where have you ever had a situation where you are told the first statement to be disposed is supplementary statement? If we're to ask the senior counsel, where's the original statement? He won't produce it. So if this is the original statement, let it be, let them go and correct it. So it serves here properly. And then we all proceed. And what makes it painful is that it doesn't matter whether colleagues want to do whatever they want to do. We debated this matter many times in this committee and emphasized that General Mkhwanazi will have to dispose a statement to the committee, even if it means cut and paste, as long as there is an original statement to the committee. So that answer doesn't even, General Mkhwanazi doesn't get involved anywhere. He was called, he was asked questions, he was being helped by evidence leaders on how these things can be done. So to invite him now and say, is this an original statement or not? It's incorrect. He gave them what they asked him to give them. If they were not satisfied, they were supposed to come back to us. Now, the legal team does exactly what we want when we appointed the legal team. That there's no legal team which is going to take decisions on behalf of this committee. Now, he goes and takes a decision that a supplementary statement will be an original statement and brings it here and embarrass us in front of cameras like we are a group of people who don't know anything. He says, General Mkhwanazi took an oath at the Nhlanhla Commission. And therefore, because he took an oath at Nhlanhla Commission, because we do what Nhlanhla has done, why should he take an oath here? If that's how it works. He disposed the statement at Nhlanhla. This statement at Nhlanhla is the statement before us. We must accept that. We must also accept Nhlanhla's oath. Going to take an oath twice on the same statement. On the same statement. There's no law that says that. I might not be a lawyer, but I'm a lawmaker.
Honorable Skosana.
Yeah. Thank you, Chair. I'm not sure, Chair, whether when we sat on our meetings, in fact, before even this ad hoc committee was set, because we sit in these portfolio committees, and it's really embarrassing, I must say, that after we agreed that we are not a subcommittee of the Nhlanhla Commission, and now we are told that there's a supplementary thank you, Chair. Not because you are talking to someone there. That we have to have a cut and paste is not acceptable as well. I mean, we were told that there was a consultation with the Provincial Commissioner General Mkhwanazi. We are going to be having a different view, you know, here at the other committee, not what we are told today by the senior counsel. And I think that I will support my colleague on that. Perhaps it would be proper that General Mkhwanazi is excused. Us as committee members discuss this matter, because really we are letting the country again down. It's like we don't know what we are doing. We know where we come from in this country. You know, we had a case where somebody was sentenced without trial before standing before the judge. Today we are finding ourselves in this again, where we are told that the statement was done, the oath was taken in the Nhlanhla Commission. It's unacceptable. And I think we should not go that route. My appeal to you, Chair, and to members is that perhaps can we take an adjournment on this matter? I think it will be proper. Otherwise, we'll be continuing doing the wrong thing. We are not a subcommittee of Nhlanhla Commission. Whatever happened at Nhlanhla Commission happened at that commission, not here. I thank you, Chair.
Yeah, no, thank you very much, Chair. Chair, let me start by sharing my deepest discontent as well. That we are starting on a very bad note. From the word go, we are messing things up. And I think we shouldn't allow that if we want to enjoy the respect of South Africans. Chair, we deliberated on this, and I remember we did not only deliberate on this during our ad hoc committee meetings, even during a joint committee meeting between the Portfolio Committee on Justice and the Portfolio Committee on Police, which gave birth to this committee. We debated the role that should be played by Parliament. And we said the doctrine of separation of powers is very clear on the role that should be played in terms of the constitutional mandate by each state or by each organ of the state. But today, we find ourselves in a situation where we are being misled by the technical team or by the legal advisors of this ad hoc committee, because if you say we must rely on the statement of the Nhlanhla Commission, you are simply subverting the constitutional responsibility of Parliament in this regard. And let's avoid this thing of mentioning Nhlanhla. Nhlanhla is a decision of the executive, not a decision of Parliament. We are doing our own, we are initiating our own process here. So we're not going to do any copy and paste kind of work and said, no, because this one has been done by Nhlanhla. Because if we are doing that, in future, we are going to be told that we can't investigate some of the issues here in the terms of reference because they were investigated by the Nhlanhla Commission. So, Chairperson, our view is very simple on this one. This must be amended. We are not going to accept this document as it is termed as a supplementary document. It must be an original statement by Lieutenant Nhlanhla General Mkhwanazi, because even the terms of reference, they are not similar. They are slightly different. So we can't be subjected to a process, some of us that do not even have a confidence in. Because some of us don't have confidence in the Commission of Inquiry. We don't have confidence. Now you want to take the work of that commission and impose it here. We're not going to allow that. Thank you very much.
Thank you very much, Chair. Thank you very much, Chair. Chair, you will recall that the Senior Counsel did confirm to us in the last ad hoc committee meeting that there will be an original statement for the work of the ad hoc committee, and the Commission of Inquiry statement will be just an attachment. So when I saw that the statement itself is addressed to the chair of the ad hoc committee, I thought that's what we have agreed about. So when I saw supplementary, I thought that the general is supplementing the statement of the 6th of July. So hence, I didn't notice what Honorable Malema has noticed. I think, Chair, it's just unfortunate, and we must plead with our evidence leaders to avoid making such mistakes so that we don't tamper with the credibility of the process itself. So in trying to mitigate the situation, maybe, Chair, because it's supposed to be sworn statement instead of supplementary statement. So I would want to request that we adjourn for 15 minutes and that defect be cured. Then we take the general to be administered in terms of oath. Then we proceed, Chair. Thank you very much.
Honorable Mwango.
Thank you, Honorable Chairperson. Good morning, colleagues, and Honorable General Mkhwanazi, you are not honorable member yet. Yes, I would like Honorable Chairperson to support the proposal that we adjourn this meeting for 15 minutes or so and correct these distortions that are in here, because the letter written to you, Honorable Chairperson, which is attached, which is part of volume 1, actually reads, please see under cover hereof the witness statement of Lieutenant General Mkhwanazi. It doesn't talk about a supplementary. But on the following page, the following page actually starts off by saying supplementary witness statement of General Mkhwanazi. So clearly there is a distortion here. So I think this needs to be corrected, but it cannot be corrected in front of the cameras, but we need to adjourn and then get these things corrected so that we can resume our job.
Okay, let's do like this so that I have listened to what you have said, and you are very right. The two institutions are separate. Every document that comes here before Parliament must be an original document before the eyes of Parliament. But maybe what we must do is that before we adjourn to correct the typo, I'm going to ask respectfully General Mkhwanazi to confirm that the statement that has been made, I know that procedure.
On a point of order, Chair. On a point of order.
Yeah, can I finish what I'm saying? So
on a point of order, Chair.
When you call the point of
no,
order.
No, it's on a point of order. We are about to mess up. On a point of order.
Okay, point of order taken.
There is no General Mkhwanazi before this committee. He's not here until we've satisfied his appearance before us. It is procedurally wrong. Because once you talk to him, the first thing he must do, the first step he must do is to take an oath. Is to take an oath. Then, only then, he's before us. In the absence of the oath, let's release him. He's not part of this mess. He's a witness called to come before us after he was told he met all the requirements. You can't ask him anything. The only time we are going to interact with him, because if you ask him something, I'm also bound to ask him something, because me and you enjoy the same rights. And then the whole house is going to start asking him questions. He has not administered an oath of, has not taken an oath. So please, Chair, we are all agreed. Let's release him. And I don't know if 15 minutes is realistic, because he's going to take up issues with the legal team as well when they arrive there. So I I don't know, but to engage General Mkhwanazi is actually out of order because he's not before us. He has to first take, he's not a member of parliament. He has to first take an oath, and then from there we can engage him.
Yeah. No, that is a valid point, Honorable Member, and I 100% agree with you that he is not properly appearing before us. And before we ask him any question, he must have taken an oath with us. And I will stand by your advice because I wanted to save, and I understand that procedurally I would have been wrong, so that we must know whether we are going to proceed or we are not going to proceed. Because for us to proceed is only if we can know whether what is contained in this document that is before us is what he's going to agree with. That yes, this is what I deposited before you. And then the corrections which are made must be made. And then we reconvene and proceed. But for now, I agree with Honorable Malema that we will not be able to ask him any question until he has taken a statement with us. So we are going to break now. We are going to break senior council and determine whether the mistakes that are on the document are correctable. Yes. Let me take senior council, Honorable Mvadomva.
If I may just remind the honorable members of the events leading up to this hearing. After the National Assembly appointed this committee, the Nhlanhla Commission had also been established. Central to this committee's terms of reference were the allegations made by General Mkhwanazi. When we at some point suggested or proposed that perhaps we should make a start with some other witness so that at least we can get the hearings going, the committee, I think near unanimously said no, we must first call General Mkhwanazi. But General Mkhwanazi became unavailable and wrote to you in that regard. And Judge Nhlanhla had also spoken to you, and the evidence leaders to me, to say, unfortunately, General Mkhwanazi is engaged initially in statement taking and subsequently that he would be appearing before them for 4 or 5 days. And that made General Mkhwanazi unavailable. You, Chair, in an exchange of letters with Judge Nhlanhla, agreed that we will, by way of cooperation and mutual respect, work together and try and save some time and unnecessary costs by exchanging documents and witness statements, etc., without either of the two parties, because of the separation of powers, being bound by what the other had either drafted by way of the documents or any evidence that was given. To the extent that it has been said or it's inferred that this committee, and we are bound by the Nhlanhla statement or the evidence that General Mkhwanazi gave before that commission, is not correct. It's not legally correct. We are not bound by it. But to the extent, and that is what General Mkhwanazi says at paragraph 8 in his sworn statement, which has now been sworn and which is an original statement. He says that I consulted with the committee's evidence leaders on 25 and 26 September. Having reviewed the terms of reference, I observed significant overlap in the background factual issues and evidence are provided.
Let me stop you there. Let me stop you there.
So can just conclude, Chair.
Just hold it there, Senior Counsel. You see, the problem may not be the contents of the statement. The problem is that this document, when it appears before the committee, it must be an original document that the committee can have or can claim ownership. And that is why members have a problem with the use of the word supplementary on the document. It must be original statement made to the ad hoc committee by General Mkhwanazi. So if you go to the contents, you are trying to justify a document that self-justifies itself. So we want you to correct that mistake of using the word supplementary on the document. Let it become an original document to the attention of the ad hoc committee of Parliament.
The Chair, may I request that we simply be directed or instructed to remove the word supplementary. I think that is the unfortunate word that has been used. This is, and General Mkhwanazi can confirm it under oath, this is very much an original statement that we've taken.
Senior Counsel, I hear what you are saying. The members are saying that he can only confirm those documents once oath has been administered. So if there is a weight that suggests that this document has been brought from elsewhere and is not our document, this meeting will not proceed. So if you were to write original on the document and then you bring it here, there is nobody who will have a problem with it. It is only the witness himself or herself who can have a problem to say, why do you say this paragraph is original? Because it's not what I deposed with yourselves. So the members are requesting that, or are instructing that. The document cannot be supplementary. Parliament has original powers. And for sure, you also know that in this country, we practice what we call parliamentary executive system. The executive itself is a creature of parliament. Without parliament, you don't have the executive in the South African parliamentary system. So can we please adjourn without deliberating further on these matters and get to a point where the witness is called to own the statement or not, please?
Chair, may I just say lastly that
no, Senior Counsel, I'm not, you know, if I'm not allowing members to speak, I can't allow you to speak any further. We adjourn and then we correct.
Check, I want to raise on a different point.
Yeah, it's a separate. Yeah, no, it's fine. You will raise that point when we are a committee. Yeah.
Because I don't think what the senior counsel is doing to you is acceptable. You can't allow that.
Yeah, what
you
I'm
can't allow
saying,
being undermined like that.
What I'm saying, honorable members, is that
I really have no confidence in him from what he did now. We must change him.
I have
to argue with us and argue with you in front of cameras, and you allow that.
I have restrained the senior counsel, honorable member. So what we should do is to adjourn. The instructions are very clear. Let's correct the statement. We must look, our business is to allow the witness to make a presentation before us. And senior counsel, please help us to have, the witness is here. Please help us to have the witness making the presentations, which not me and you, but which South Africans want to hear. Please, let's do this for the people of this country. And I have said we have agenda for that correction to happen. Thank you so much.
Chair. Yeah, the statement has not been signed. The statement before us, there's no signature.
Yeah, that is technical.
No.
No, it's technical.
No, but it can be.
We have agenda.
Chair, for how long are we adjourning? Chair. Chairperson. He's not. For how long are we adjourning? For how long?
Chi, 1, 2. Ephraim, can you hear me?
Uh, Honorable members, can you honorable members, I'm going to request we do like this. We must get a report from the team because they are now back, and I'm going to release all people who are not members of the committee, so that the committee makes a decision on the manner of proceedings. But the committee members heard what I said, that everyone who is not a member of the committee is being released now. We remain with the committee members to determine on how we proceed. Yeah. Thank you. Thank you so much, honorable members. I think the reproduction of documents has been
constitutional law. But I have also done work in the areas of labor law. I do quite a lot of work in the personal injury field, mostly representing, in fact, entirely representing the state in those cases. I have, over the years, developed a reasonable amount of commercial work, but it's not the main part of my practice. And then, as time has gone by, I've done a couple of different areas. I've done a small bit of matrimonial work, and a few things like that. Yes.
Okay. I see from your questionnaire that once upon a time you were a member of the African National Congress. Those ties are no longer existing,
Yes.
according to this information. All right.
Yes, I was a member of the Salt River branch of the ANC, and I resigned when I was appointed to the Land Claims Court.
All right. And it is mentioned somewhere that you were once court-martialed. Would you want to tell us a little bit about that during a touchy period in our history?
Yes.
Yeah.
Refusing
to
disclosed,
do something.
I don't mind talking about it. I have a military criminal record. I was ordered during a military camp to do armed patrols of the townships around the south of Durban, and that would have required me to act completely against my conscience, against my moral perspectives, and against my political perspectives, and I refused to do it. It in fact happened twice. On the one army camp, they accommodated my refusal and they made me stand as a guard somewhere. And then on the second one, they weren't willing to accommodate me, and they said, if you continue your stance, we're going to order you, and if you don't do it, we're going to court-martial you. And that is what happened. So I said, I'm not willing to bend. And I was then court-martialed in the Natal Command, as it was called, in Durban.
Well, you have had an opportunity to act at the Constitutional Court. When was this, and how long was your stint or stints there?
I acted for 2 terms. The first was in the last term of 2023, and the second was in the first term of 2024.
And you wrote judgments during that stint, which have since been delivered?
Yes,
How many?
I scribed, I think I scribed 3 judgments, and I wrote a dissenting judgment.
And you would have penned judgments during your time in the Land Claims Court as well?
Yes, yes, indeed. And there's a list of those attached to my CV where they have been reported.
Yeah.
Yes.
All right. And in the middle of everything else, you've managed to write articles on legal issues, published articles.
Yes, I have written a few published articles, and they've tended mostly to focus on my area of expertise, which is one of my areas of expertise, which is in the area of land reform, obviously arising from my experience both on the Land Claims Court and in Kosovo.
Yeah. You have mentioned that you once had health issues which has since resolved.
Yes, I had a form of leukemia. It had no consequential symptoms. It was discovered by chance, and I've had chemotherapy, and the result of the chemotherapy was completely successful.
And you managed to lead a healthy, active life.
And I managed to lead a healthy, active life. Yes, I try and do a couple of bicycle races each year. I also try not to fall off the bicycle, which is also not good for one's health. But yes, I do lead an active life. Thank you.
I raise this for the large part because of your age. You are 65 this year.
Yes.
How long does that leave you to serve on the bench if you are appointed?
It gives me just short of 10 years. And
Another 10 years.
yes, and that's the combination of Section 176(1) of the Constitution, read with Section 4(2) of the Judges' Remuneration and Conditions of Employment Act.
All right. Okay, I will leave things here for now and hand over to the commissioners to put questions to you.
Thank you, Chief Justice.
Starting with Judge President Nhlanhla.
Thank you, Chief Justice, and good day, Advocate
Good day, Judge President.
Yes, just a quick one. Given your practice in the Constitutional Court, where you appeared and having acted there, is there any special skill that you would say is lacking, that you would have identified that we need to build on at the Constitutional Court?
Sorry, I didn't hear the last part of your sentence. Any special skill
Yes.
that is lacking that?
On that bench, that you would say it needs some attention.
I would not say that there is any lack of skill at the Constitutional Court, having worked there. I worked together with an extraordinary group of permanent colleagues who were deeply impressive, quite apart from the fact that they were extremely welcoming and wonderful colleagues to work with. Rather, what I would say is that what is lacking is resources. I think that the Constitutional Court was unfairly allocated a massive expansion of their jurisdiction when they were given a general jurisdiction on non-constitutional issues, with absolutely no increase, it seems to me, in the resources that were made available to them to deal with that additional surge of work, which has most certainly come. And there I believe, while I was there, I was able to play something of a role. I became involved in discussions about what might be done in that regard. I wrote a memorandum at the request of the other judges, giving some ideas about how the workload there may be able to be addressed through a constitutional amendment. And in fact, as part of that process, just to try and assist in discussions, I prepared a draft amendment to the Constitution that might cater for panel decision-making, similar to what takes place in the Supreme Court of Appeal, where applications for leave to appeal are dealt with by a panel of 2 judges, or if they disagree, a panel of 3 judges. Something which I think could make an enormous difference to the workload of the Constitutional Court.
You say the panel will work well for the apex court, which is the court that's got the last say, where you reduce it only to a few judges to decide an issue.
Sorry, I'm really battling to hear you, Judge President, if you wouldn't mind repeating the question.
Okay, sorry, you said you supported the idea that there should be panels,
Yes.
like the SCA. But isn't the difference that the Constitutional Court is the apex court, and you'll be reducing decisions to only a few judges, whereas every judge of that court is expected to have a say on any decision as the law as it stands?
Yes, no, that I agree with you. That certainly is, in terms of Section 167(2), that certainly is the law as it stands. But unfortunately, there has been a surge, I think, as a result of that expansion of their jurisdiction. There's been a surge in applications for leave to appeal and applications for reconsideration. And some mechanism is going to have to be found to deal with that. While I was serving on the court, Chief Justice Zondo, on a trial basis, brought in 2 retired justices of the court to assist with applications for leave to appeal. But for various reasons, that wasn't followed through and wasn't found to be an optimal solution. But some solution does need to be found to assist in that process. For example, if one looks at the Supreme Court of Canada, they have an entire branch of permanent career lawyers within the Supreme Court that provide ongoing assistance to judges with dealing with things like applications for leave to appeal, obviously preparing. And there needs to be something that has to be done to assist the Apex Court as far as that's concerned.
I see. Would you agree that the development and quality does not lie solely at the Apex Court? The other courts have got a role to play, and strengthening those courts would go a long way to maybe to address even the problem that you have identified.
I would absolutely agree with that, Judge President, 100%.
Yes. And one has noted that it's not every case that goes to the Apex Court. You might have bad decisions, especially of those who cannot afford to take matters on appeal, having to comply with bad decisions which remain unchallenged.
Indeed. And as you point out, for many litigants, it's a luxury to be able to go all the way through the court system up to the Apex Court. And that's why the jurisprudence at high court level is so exceptionally important.
Yeah. Given your enviable CV and experience, I would have loved to have seen you maybe attempting to make yourself available starting at the High Court, and maybe also improve the jurisprudence at the SCA level. What's your view? Or is it with you, it has to be at the Concord?
Thank you for the compliment in relation to my CV. I appreciate that. I have followed a route towards the Constitutional Court that is recognized in terms of Section 174(5) of the Constitution. I have certainly acted fairly frequently in the High Court. I have also seen my time during practice as an opportunity to use my position as counsel to try to also there bring about aspects of transformation. I've tended to focus on cases that make a difference. And I think that in that role, I have been helpful to the high courts. All of those cases have to make their way up through the court system. So, for example, I've litigated quite extensively around the issue of how you deal with compensation for medical negligence claims, and have put a lot of work into presenting cases to the High Court there to give the judges there the opportunity to consider the evidence and arguments we present and to take those forward. So, yes, I started off as a judge in the Land Claims Court. It was a court of equal status to the High Court. I left for the reasons that I left. I then had a spell in practice. The nature of my practice and the cases I have done, I think, means that I can be of assistance to the Constitutional Court. My experience when I acted there was confirmatory of that. That is the reason that I followed the route that I have done and the slightly unusual career path that I have done.
Yes. Thank you. Thank you, CJ.
Thank you, Judge President.
Commissioner Marumachai.
Thank you very much, Chief Justice. Good afternoon, Advocate.
Good afternoon, Commissioner.
I have two questions for you. The first question is in relation to Section 167, subsection 6 of the Constitution, direct access. It appears to me that that particular provision is quite clear. The circumstances that can lead to that court attaining direct access to a matter are quite clear. But in practice, it does not seem as if the Constitutional Court has provided clear guidelines as to when a matter will be ripe for it to be heard by that court on a direct access route. I'm not really sure. What is your view in relation to the jurisprudence surrounding Section 167?
I mean, the criteria that it ultimately always comes back to is whether it's in the interests of justice to allow direct access. And my sense is that that's going to be a very fact-driven inquiry as to whether, in a particular circumstances, something is in the interests of justice. And I think that may lead to a perception of unpredictability about it. But I think there are some principles that are established there. And perhaps the most important one is the principle that's been well established by the Constitutional Court, that their preference is to hear the views of other courts rather than litigants approaching them directly. Obviously, there are cases where the urgency of the circumstances prevent that. But speaking as a practitioner and speaking as somebody who has acted there, I think that it would be something that, as a practitioner, I would always advise a client to be very cautious about. One accepts also from having practiced there that there's a huge workload. One accepts also from having acted there that it's not a court that's designed to deal with urgent applications, because at least 8 of the judges have to participate in the decision making. It's going to be difficult. So I think, yes, potential applicants do need to accept that their chances are limited of being able to get direct access. The court is going to be slow to accept direct access cases. And I think, with respect, rightly so from the court's perspective.
Thank you very much. My second question is in relation to a case that dealt with the intersection between labor law and competition law, where the court had to consider whether the retrenchment of workers violated conditions attached to a merger approval. That is Coca-Cola Beverages versus Competition Commission. Do you remember that case?
Yes, it's one of the ones that I described.
My sense was there was a need to strike a balance between the expansion and sustainability of corporations in an open market and the need to protect employment. And that case traveled from the tribunal, where the tribunal used the so-called but-for test, the causation test. And then it went to the CAC, which developed a test that one can describe as some nexus sort of test. And when it eventually came to the Constitutional Court, it appears to me that you advocated for what can be described as a true reason test, which was, it appears, might have been crafted somehow by the tribunal in some ways. Now, there has been some criticism that the test that the Constitutional Court has adopted here potentially destroyed the protection given by the Competition Act to employees likely to be retrenched for reasons related to mergers, and to also allow firms to avoid merger protections merely by indicating that there are other reasons for retrenchment and that the merger played a marginal role in the retrenchment. Based on what I've just said, one, do you think the criticism is fair? Secondly, is there a scope to really use the test that has been advocated for by the CIC? Because there are people who are saying that perhaps that is the test that seems to be protecting employment more than the one that is adopted by the Constitution, by the Constitutional Court.
I obviously reread the judgment in preparation for this hearing, and would also, as with any judgment, read it with an open mind and one that is open to criticism. But I think that if one looks both at the content of the agreements that were reached with the trade unions, in that case, in relation to the conditions and the way that they were worded, particularly using the words as a result of, and if one looks at the statute and applies statutory interpretation principles to it, I think there's a difficulty with a standard that simply is as low, as it were, as some nexus, because it contemplates the possibility that, yes, the retrenchments were not as a result of the merger, but there is some nexus. And I think that would lead to the potential for injustices. The legislation is clear, and I think that the scope is still certainly there for anybody in a future case, provided they're able to prove the necessary causal links as far as merger and retrenchment are concerned, to be able to prevent retrenchments which are truly retrenchments that are as a result of the merger.
Thank you very much, CJ.
Commissioner Ngugaitobi, followed by Minister.
I suppose I could waive my right to the minister, given
You're wasting time.
her proximity to power.
Thank you very much, CJ, and good afternoon, Advocate Judge. Is it Mickey? I must make it.
Good afternoon, Minister. Yes, advocate at this stage.
Advocate Johnson. Thanks a lot. You've done a lot of work around what I would call issues that deal with, or you have been advancing socioeconomic rights in communities, especially the poor and the vulnerable, looking at the work that you have done in NHI land claims and others. And also the work that you've done on class action, especially in the mining space. Do you think that in the manner that our current court rules, and also in the manner that our courts are structured, are conducive enough to be able to assist, especially dealing with class action for communities and in contributing to access to justice?
My short answer is no. There's a lot that has been done, but there isn't nearly enough that has been done as far as access to justice by all South Africans who want to make use of the court system is concerned. The reason for that is that our system is based on an adversarial system. An adversarial system works well when you have parties on each side that have legal representation, number one, and number two, that have legal representation that is of more or less equal skill and resources and so on. And unfortunately, there are many times where that is not the case. The worst case scenario being when a person is completely unrepresented against somebody who is indeed represented. Of course, there are many things that have been done to address that, and we must acknowledge what has been done since 1994. For example, during my time as a lawyer before being appointed to the Land Claims Court, the legal aid system was hopelessly inadequate. There is a lot of work that has been done to improve the legal aid system under the guidance of some of our leading judges as well. And I think we now have a system where, from a criminal point of view, I think legal aid has done exceptionally well in ensuring that people have the possibility of being legally represented in a criminal trial. Where legal aid hasn't yet come up to scratch is in the area of human rights law and civil law. And there it's a real resources problem. Legal aid needs more funding. We also have an exceptionally vibrant NGO law clinic culture in South Africa, and one has to take one's hat off to the work that they have done in in advancing representation of people in South Africa and extraordinary achievements that they've done. One must also acknowledge the work of the drafters of the Legal Practice Act, who did a great job in recognizing law clinics, creating a proper space for them in the regulatory setup for the legal profession, and also giving them special privileges in terms of the recovery of costs. So I think that has gone a long way in terms of helping people. And Minister, finally, as you pointed out, the introduction by the Constitution of the class action mechanism does provide a very important mechanism for extending justice. In the silicosis litigation, for example, we were able to extend justice to people who'd worked as miners in South Africa but came from countries outside of South Africa's borders. So that does present opportunities. But I come back to my original answer. Sorry, the answer was long. No, I agree with you. There's not adequate access to justice.
And just to follow on that, thanks a lot. And what do you think we should be able to do? Because if we acknowledge that definitely there are challenges, and in terms of what our forebear envisioned in the right to access to justice and for all of us to be equal, but to have equal access to justice, what are the areas you think that you should be paying attention to? But also, you're coming to the Constitutional Court, should you be considered? What role and what input would you make to ensure that such communities that you're talking about would be able to have this right that we talk about, which is fundamental in our Constitution?
In addressing it, obviously, legal aid needs more money. That's the first and a very clear thing. Another mechanism that we had available to us on the Land Claims Court, and that has been carried over into the Land Court Act, is a provision that says that the court may, in its discretion, act inquisitorially. And when I was on the Land Claims Court, I and other judges were able to use that position when we perceived that there was an inequality of arms between the different parties that might result in an injustice, to seek to see if we could find ways of ensuring that an injustice didn't result. And I think that provision could be extended to other courts. It could be introduced into the rules of court, and I think that perhaps also with an element of training, judicial training, around limited possibilities for inquisitorial intervention, a significant difference could be made. As far as the Constitutional Court is concerned, my experience when I was there is that the Constitutional Court is quite spoilt, in the sense that when there was a situation where somebody wasn't represented or there were problems in that regard, there were a range of organizations that were willing to step in and assist, including PABASA, AFT, the Bar Council, and I was impressed at how readily advocates would make themselves available and attorneys would make themselves available at short notice to come and assist and present argument on behalf of parties at the Constitutional Court.
Thank you. Thank you.
Thank you, Chief Justice. Advocate Dodson, I just have two questions. I mean, the first one, I suppose, because you are a land specialist, is to ask you whether Section 25 of the Constitution is capable of being interpreted to include a requirement that there should be a right to property equality.
To property equality?
Yes. Or to land equality.
Well, as I read Section 25, that is ultimately its driving force, is to strive to achieve land equality.
Yes.
And I think its beauty, in a way, is it doesn't just say that it doesn't just say that there's a right to property, for example. it goes on to give us very specific mechanisms to strive to achieve land equality.
So there is a constitutional right to land equality. That's your starting point.
Yes, I would say so, as interpreted through the redistributive security tenure and restitutionary components of Section 25.
Yes. Now, and at the moment, in the context where we have land injustice and land inequality, we are probably in breach of that section. The government is in breach of that section.
I would be slow as somebody who is a candidate for sitting on a court when an argument like that might come before it.
But I mean, I suppose
to declare the government in breach, and let me also say, in fairness to the state, bearing in mind, in my practice, I act for all sides. I've acted mostly for communities and claimants, but I also act quite substantially for the state, particularly the Commission on Restitution of Land Rights. And I've also on occasion acted for property owners as well. I would be slow to simply say that the government was in breach, and I think one would have to, before coming to any conclusion, look at things a lot more carefully and closely. And it's in the kind of specifics where I think you would get answers. So, for example, I was involved in the Lamosa litigation and the Speaker of Parliament litigation, which looked at new claims and their impact on old claims. So it seems to me it's a kind of question that only develops answers in specific contexts. So in that particular context, yes, you had a situation where old claimants, as we call them, people who claimed before 1998, were confronted with not being able to get land justice, many of them because they're old, and it really remains a very big problem. So a solution was found, government was there found to be in breach, and a solution was found.
Yes, no, I perfectly appreciate that you don't want to commit yourself to the question of breach, but you can commit yourself to the question of principle. But then the second issue that arises from the first answer, which is there is a right to land equality. Is there a right to property equality?
I mean, what's difficult about that is that that's a completely novel area as to what is property. I know, for example, in your judgment in Sibanyoni, you pointed out very correctly and forcefully that cattle constitute property and a very, very valuable and important part of property.
Yes.
But I'm not sure that one could simply at this stage say that there's a right to equality of property. The reality is we live in a country that has inherited a particular economic system. We live in a country that also comes from an era when there was very aggressive efforts at disadvantaging the majority of South Africans, which have left them in a lasting unequal position. But we didn't have a complete revolution when democracy came in. It was a negotiated solution, and that was based on its own choices, policy choices, and has had its own consequences. It's an argument I'd like to leave open for somebody to come and argue were I to be appointed as a judge.
All right, okay. You'll also leave that question open. All right, fine, no problem. Then the second question, the real second question, is around the answer you gave on the mechanisms of the Constitutional Court and why there are delays. I'm not sure if there are delays. I think many judgments are given on time. There are probably one or two that delay. But nevertheless, the real issue I want to explore with you is whether you've done some research with comparable courts. I was looking yesterday in preparation for this interview at the US Supreme Court. They have for what they call a writ of certiorari, a rule of 4. They get 10,000 applications every year. They hear about 80, but every judge reads every application. Of course, through clerks, and I mean, not necessarily personally, you put your eyes over the piece of paper, but through systems in place. But the rule is that every judge must read every application, and if 4 of them want it set down, it will be set down. And once it's set down, if 5 of them agree, that will be the outcome of the court. I don't think the court receives 10,000 applications, the Constitutional Court. I don't know how many cases it has per annum. I'm not sure if it's 70 or 80, which is the same as the American Supreme Court. So somehow you have a system there that is capable of managing large volumes of work, because it's also a court of general jurisdiction. And so there's something else that perhaps still needs to be accounted for to explain the delays or to explain the structural inefficiency. And the question is, what is it? Because it does not seem to be the volumes only, something else that we are still yet to point our fingers at. And what do you think that may be?
I didn't hear the last part. What do I think?
What do you think that may be the distinction between why the US Supreme Court is able to read 10,000 applications, certify about 80 of them for hearing, and dispose of them quickly? And our Constitutional Court, which does not have a comparable volume.
Your question started with whether I've done research. The only research that I have done was a little bit of reading on how the United States Supreme Court controls their docket and how that came about. But if you read about what happened, is a statute was passed. I can't remember which year it was. I think in the last century, early in the last century, a statute was passed which gave the court specifically the power to control its docket. So expressly to exercise the discretion to limit, possibly even justifiable cases from coming before the court to manage its caseload. And if you look at the complaints that came from the judges before that statute was passed, it has a resonance with what I was hearing and seeing when I was acting in the Constitutional Court. The judges in the Constitutional Court work exceptionally hard. They work exceptionally long hours, and there is no shortage of industry on their part to try and get through what they get through. But to me, it seems that one needs to sit down and analyze the problem. And I'm sure that there are ways in which one can work out mechanisms for resolving, getting through the large volumes of applications for leave to appeal. But the reality is that the applications for leave to appeal are taking up, as I saw it, time that should really belong to thinking about and preparing judgments. And yes, I think that when the court needs an opportunity to sit back, analyze where it's going wrong, analyze what can be achieved through a constitutional amendment, and analyze what can be achieved through an increase in person power. When we spoke, while I was there was a visit from the Supreme Court of Canada, and they've got this echelon called the Law Branch, which, as I said, was a group of professional lawyers who have full-time careers there. And I think they play a huge role in getting these applications for leave to appeal ready for consideration by the judges. But they do operate in panels. They're the highest court in the land, and they do operate in panels, both panels in terms of, as I understood it, applications for leave to appeal, but also panels in terms of the actual adjudication of cases. So you can have cases where I think it was 5 judges sit to hear a case and would be recognized as a quorum. And one of the thoughts that I had, I haven't taken it any way down the road, but maybe one could have a system where when the Constitutional Court acts under its constitutional jurisdiction, under that provision, even if only partly, one sticks to the en banc decision-making, the full bench decision-making requirement. but maybe for consideration is when one is dealing with its general jurisdiction, one allows, for example, 4 or 5 person panel. As I say, I haven't thought it through carefully, but I think there needs to be the opportunity for sitting back, reflecting, and seeing what can be done to manage that caseload.
Thank you, Chief Justice. Thank you, Mr. Dodson.
Just to add to what you said about Canada, I don't know about the US Supreme Court. It probably has the same systems, but most apex courts have sifting measures so that not all process that comes to the court has to have 11 minds of the justices bear, upon each and everyone, even the unmeritorious ones. And this constitutional court is in the process of trying to get a professional board of lawyers, similarly to other apex courts elsewhere, to assist it with these problems. So that's just one measure, and it will be interesting to hear other views from people such as yourselves, Advocate Dodson, on how we can resolve our issues. But I just want to endorse what you said, that justices in that court work extremely, extremely hard. We exchange emails at all sorts of hours on the daily for little or no pay, I may add.
It was really to deal with the concern raised by JP Tlalezi, that at the apex court, the litigants expect the benefit of having all of the eyes reading their petitions, but then that's not practical.
Yeah.
Yeah.
Okay, it's Commissioner Mangena.
Thank you, CJ. Good afternoon, Advocate Dodson.
Good afternoon, Commissioner.
Can't hear you, Commissioner.
Oh, I don't know what's happening with this. Is it better?
Yes.
Advocate Dodson, I've got one question, depending on the answer that comes. It may be two. A precedent is an incident of the rule of law. Precedent, stare decisis, right? Now, you are going to, if you are elevated, if you become successful, you'll be elevated to the Constitutional Court, which is the apex court in the country. Can the Constitutional Court depart from its own judgments? And if so, under what circumstances?
Yes, it can, but only where it finds that its previous decision was clearly wrong.
In the period that you have been there, and from your reading as well, have we had a situation wherein the Constitutional Court had departed from its own judgment?
Not while I was there, no.
Thank you, CJ.
Any further questions? President, followed by Commissioner Hassan.
Good afternoon, Mr. Dodson.
Good afternoon, President Monamela.
How are you?
I'm well, thank you. And how are you?
I'm well, thank you. My question relates to the provisions of Section 167, subsection 3 of the Constitution, and I confine it only to the general jurisdiction of the Constitutional Court. Now, that provision states that the Constitutional Court has jurisdiction to hear matters that raise an arguable point of law of general importance, which ought to be considered by that court. What, in your view, would be relevant factors for purposes of determining whether a matter raises arguable points of law of general public importance?
If I can just get a moment to have it open in front of me, if you'll just bear with me. But essentially, the court has laid down what its approach will be to the interpretation of that particular provision. And it's really determined with reference to the wording of the particular, the components of the wording of the particular section 167(3)(b)(2). So first of all, there's a requirement that leave to appeal must be granted, which immediately brings into play the requirements of interests of justice, prospects of success, amongst others. Then, on the grounds that the matter raises an arguable point of law, and that obviously is quite a well-established test that ties in with that ties in with the reasonable prospects of success criterion. Probably a pithy way of asking, are there reasonable prospects of success in this particular case? And then of general public importance, obviously that brings into play the criterion that the determination of the particular issue in respect of which jurisdiction is sought must extend beyond the interests of the immediate parties to the dispute and have a potentially broader impact for the rest of society.
Yes. So, sorry, if I may come in, just to qualify the question. Leaving aside prospects of success and confining yourself to to arguable points of law of general public importance, can you maybe give one or two examples of what you consider to be such a matter? In other words, a matter that raises important points of law of general public importance. One or two examples.
Yes, I think the example that immediately springs to mind is the judgment that I wrote in the Huntrex case, which related to a servitude to cultivate a garden on a neighbor's property. And that was a case where the respondent specifically said, this is not an issue that deserves the attention of this particular court. It's a fight between two neighbors and doesn't go beyond that. But once one looked at it a lot more carefully, it fell quite neatly within this particular category of jurisdiction, because it impacted not only on the immediate parties to the dispute, but if it was a predial servitude, it would carry on ad infinitum in respect of all future owners. It also emerged on the evidence that registrars of deeds were registering similar servitudes without having regard to whether or not they were indeed lawfully registrable. So yes, that I think would be for me the clearest example that I came across in my experience while acting there.
Yes, thank you, Chief Justice. The second question. So the question, it's actually a follow-up on your previous response, but I want to pose it having given you a preamble of what the Constitutional Court said in two matters. And the question that I'm going to ask thereafter is, under what circumstances should the Constitutional Court consider it not to be in the interest of justice to decide factual issues that pertain to the merits so as to correct the erroneous evaluation of facts by a lower court? And now, the following, and I quote, if from the record that the trial court misdirected itself on the facts or that it came to a wrong conclusion, the appellate court is duty-bound to overrule factual findings of the trial court so as to do justice to the case, unquote, meaning interest of justice. In the interest of justice, then they have to do that. And then in a second judgment, the Constitutional Court said the following: the public interest will be best served by prompt resolution. Such resolution will help to correct the wrong decision before it has further consequences on one hand, and to avoid delay and inconvenience resulting from the failure of this court to hear the appeal on the other hand. The evidence is sufficient to enable this court to deal with and dispose of the matter without referring it back to the Supreme Court of Appeal for reconsideration. It goes without saying that the interests of justice require this court to entertain the matter, as remitting it to the Supreme Court of Appeal for reconsideration will give rise to considerable inconvenience, prejudice, and impede the attainment and administration of justice. And it went on to say, it seems that in the circumstances of the case, we should not follow that route, in other words, the route of remitting, but we should determine the appeal ourselves. This is because this court does entertain direct access appeals from the High Court in appropriate cases. The matter has dragged on for a long time, and if we remit it to the Supreme Court of Appeal, it is likely to end up back with us. It goes without saying that the interests of justice require this court to entertain this matter, as remitting it to the Supreme Court of Appeal for reconsideration will give rise to considerable inconvenience, prejudice, and impede the attainment of the administration of justice. And then they went on to say, the matter has dragged on for a long time, and if we remit it to the Supreme Court of Appeal, it is likely to end up back with us again in any event. We have already heard full argument, and we should avoid having to hear the matter for the second time. The route I propose to follow will avoid a duplication of costs, unquote. I then pose this question: when will it not be in the interest of justice for the Constitutional Court to decide a matter where factual issues have been raised, but there was an erroneous evaluation of facts by a lower court? So remember, at first I said you must give examples of when it would be in the interest of justice to consider those aspects. And now the question is, when is it not in the interest of justice to deal with matters that are raised in a particular case that are considered to be raising important aspects, points of law of public importance that pertain to factual issues? I hope you understand the question. Thank you.
My understanding of the issue in relation to factual issues is essentially that has been laid down since S versus Bosak by the Constitutional Court, and that is to see factual disputes as issues that actually fall outside of its jurisdiction. As I recall, and I can't immediately think of the cases, there may have been exceptions made in particular circumstances, but the basic rule, and the rule that was applied while I was acting in that court, was that we do not have jurisdiction in respect of purely factual disputes. That, along with a related category, which is where there is a well-established rule or principle, and the lower court gets that rule or principle right in terms of its articulation, but doesn't correctly apply it to the facts, there too, the court will not assume jurisdiction in those cases. So it seems to me that unless there's a particularly unusual circumstance, that is the way that the Constitutional Court would deal with those factual matters. They would see them as jurisdictional, and they would decline jurisdiction in them. As I understand the other part of your question, it relates more to when will the court simply go ahead and decide the issue itself, or when will it remit to the Supreme Court of Appeal? And my sense is that the main criterion that would be applied in those circumstances is to ask, do we need the input of the Supreme Court of Appeal on this issue, having corrected whatever the Constitutional Court has corrected? Do we need the input of the Supreme Court of Appeal on this issue before we come to a final conclusion, if it were to be sent back to us again following the SCA's adjudication, or it might end at the SCA if there weren't any further appeals? And to give a particular example is the Supreme Court of Appeal, they're the experts on the common law. So it seems to me that where there's a tricky issue pertaining to the determination of the common law, that might very well be an example of something that they would be inclined to remit to the Supreme Court of Appeal so that they get the benefit of their views, either by way of that presenting a final solution of the case in the SCA, or by way of, if it were to come back to them, they would then have the benefit of the SCA's expertise in that area.
Thank you very much, Mr. Dodson. Thank you, CJ.
Follow up?
Thank you, Chief Justice. Good afternoon, Advocate Dodson.
Good afternoon, Commissioner Pillay.
Just in relation to the question posed by President Molamela, how would the Constitutional Court's recent judgment in the Vodacom matter make a difference to your answer, where the court upheld an appeal based on the failure of the duty of proper consideration, and held that in limited instances where there's been a failure of justice, that would constitute a ground of appeal because it's a failure of Section 34, fair hearing right?
So unfortunately, I read the judgment on the day that it was handed down, and I haven't looked at it since then. But my sense is that the reasoning, if my recollection is right, that the reasoning is related to the point that I was making in relation to hearing the views of the next court down in the hierarchy on the issue. And the concern that was expressed in the Vodacom case was that there was no clearly discernible path of reasoning in the judgment of the Supreme Court of Appeal. And that for that reason, in a sense, they hadn't actually used the opportunity when it was in front of them to give a clear legal answer to the issue. And my understanding is, for that reason, it was sent back for consideration by a differently constituted bench, so that the court could express itself with a clear path of reasoning that would allow either the matter to be resolved there on the basis of a clear path of reasoning, or come back potentially to the Constitutional Court, but in circumstances where the Constitutional Court could see more clearly with respect why the Supreme Court of Appeal had arrived at a particular conclusion.
Chief Justice, I have a second question. May I place it now and then I'm done? Thank you. Advocate Dodson, your application was made in June 2025. And in August, the judiciary adopted its sexual harassment policy. Just to check firstly that wouldn't in any way have deterred you from applying had the policy been adopted prior to you bringing the application.
Not at all. I've read the policy. It is an exceptionally well drafted, well thought out document, extremely impressive. It puts in place sensitive mechanisms for dealing with the issues. It hearkens to the rights in the Bill of Rights as a guiding criterion in the way that it is laid down. It creates a special office to deal with these issues. Extremely impressive document, and I would not just not have an objection, I would fully support it.
Now, Section 5.1 of the policy states that sexual harassment violates, amongst others, Articles 5 and 6 of the Judicial Code of Conduct. Article 5 refers to the duty to act honorably, in a general sense, not confined to your judicial tasks. And that's reaffirmed by Article 6, which says that a judge must at all times, even in relation to extrajudicial conduct, comply with the law. Now, do you believe that the policy should apply to extrajudicial conduct?
Yes, absolutely. absolutely. The reputation of, the starting point is the victim. No person should be the victim of sexual harassment in any circumstances, at court or away from a court by a judge. So I have no hesitation in endorsing that. And from the point of view also, secondarily to the victim's rights, the reputation of the judiciary. The reputation of the judiciary is done irreparable harm if somebody were to be involved in sexual harassment, even away from the court, as it were.
Thank you, Advocate. Thank you, Chief Justice.
Commissioner Hassan?
Thank you very much, Chief Justice. Advocate Dutton over here, thank you. I wanted to ask a question as one of the younger commissioners currently sitting on the JSC. Many young South Africans, they're sort of increasingly questioning whether the Constitution still works for them. And of course, this is born from a number of different socioeconomic issues. But from your vantage point, what must the Constitutional Court do differently to regain the trust of a disillusioned generation?
I'm not sure that I can. I'm not sure that I can accept the premise, which is that the Constitutional Court has lost. The Constitutional Court as an institution has lost the trust of the younger generation of South Africans. But I have three adult children, so that's my feed-in, as it were, perhaps to that generation. What I can certainly understand is a potential loss of faith in the Constitution itself because of the...
That's actually what I meant, in the actual Constitution and the delivery thereof. So you're not wrong in your first assertions.
That I can understand. The particularly the rights from Section 23 through to Section 28 are rights in the Bill of Rights that embraced a unique promise to South Africans. Yes, a number of those rights come with a built-in reality check in the form of progressive realization, but still they hold a promise. And if you drive through any informal settlement or something like that in South Africa, you can see starkly and in your face that we're still a good distance off realizing those rights. So yes, I can understand that the loss of trust in the Constitution, and yes, it must automatically follow from that the courts, all of them, including the constitutional courts, must be mindful of that, and mindful of the need to keep faith in constitutional democracy and a society regulated on the basis of the rule of law. The best I think I can say is that those rights set a standard for adjudication which must be taken into account, and the concern you've raised must also be considered in that decision-making process.
I think just related to that, you've mentored quite a number of younger advocates. And so my next question, or sort of related to this on young people and youth, is what would that mentorship for your element look like inside the Constitutional Court, but more particularly, how can the court become an active incubator of diverse judicial talent as opposed to just a recipient of it?
I believe the court has done exceptionally well through its clerks program. It's been there for a long time. It takes place under a system of mentorship and supervision with 2 clerks allocated to each of the judges. And it presents an extraordinary opportunity for them to learn and grow through the process. I was blown away by the level of responsibility that is given to the clerks. I was blown away by the level of access that is given to the clerks to the decision-making process. Pretty much every email that you send in the course of deliberations copies in the clerks. So that was certainly something I didn't anticipate, but it's what is there. And I see the product of that approach on the part of the judges of the Constitutional Court in some of the attorneys and advocates that I work with in the course of my practice. It has produced and continues to produce the most exceptional and talented lawyers in this country. So yes, I think substantially through the clerks program, they're getting it right, but there's always more that you can do. And I don't know if having spent 2 terms there provides me with a sufficient basis to critique the court, but it has an open day in which there's an accountability to the public. And it also seems to me that if one is to accept that there could be an echelon of permanent career lawyers within the administration of the court to assist the judges, that would also provide exceptional opportunities for developing people in constitutional law.
Last question, CJ. You've chosen, advocate, to stay largely in practice and in public interest work. Why do you think it's important that the apex court also includes voices from outside the bench or this permanent sort of judicial seat? And what perspective do you believe that brings yourself in interpreting the Constitution in a very rapidly changing society?
So just to make sure I'm understanding your question correctly, you're talking about people who come something along the lines of the route that I've followed into the court and what they can bring to bear in the court's decision making.
So traditionally, people who apply for a position at the CC, of course, have been sitting judges for a very long time. So I'm interested in your perspective as somebody who's chosen to stay in practice in that way, dealing with public interest work. What benefits, what disadvantages, et cetera, et cetera.
Thank you. I believe that number one, the Constitution is designed to accept people with other career paths through the provisions of Section 174(5), which allows for up to 7 of the judges not to be serving judges at the time that they're appointed. And I think that that isn't a fossil from days gone by. I think that there's a reason behind it. And that is that in your apex court deciding such important issues, you want ranges of diverse experience influencing your decision-making process. And I think that the reality is if you accept people who might come from academia, for example, perhaps also having been given the opportunity to act as judges as well to round off their academic experience, if they've perhaps acted in the high courts, you can bring important influences to bear. Also, from the point of view of practice, I don't think should be seen as something that is a zero or a negative in terms of what your credits, as it were, are for an appointment to the apex court. I think it is helpful for the court to have somebody there who's argued through all of the different levels of court. And there are interesting parallels and differences in the kind of mental processes that go on. For example, in the preparation of heads of argument and the presentation of argument. Preparing heads of argument follows a very similar intellectual process to preparing a judgment. And I think is important experience for the purposes of drafting judgments. One's heads of argument are there to persuade the court to decide in your client's favor. When you write a judgment, what you're doing is seeking to explain, give it another word, persuade, the party that you're deciding in favor of, that the correct decision has been arrived at. So there are similar trends. There is also sometimes, and I say it a little bit tongue in cheek, a propensity on the part of judges who've been judges for a very long time to forget how tough it is out there arguing cases as counsel. And maybe having somebody who's been counsel more recently amongst you is something that brings a different perspective. But that's not obviously my main submission. My main submission is allowing people who followed a different path enriches the decision-making process of the Apex Court.
Commissioner Moimang.
Thank you, CJ. Good afternoon, Advocate Dodson.
Good afternoon.
Let me just build on the first question posed by Commissioner Hassan, but it will be also in relation to one of the judgments that you have raised in your questionnaire, Lamosa judgment.
Sorry, which judgment, Commissioner, if I may ask?
Lamosa judgment.
Lamosa judgment, yes.
Yes. The question posed by Commissioner Hassan in relation to the confidence of young people in the ability of Concord to dispense justice for all and the values as enshrined in the Constitution. In that judgment, the setting aside of restitution of land rights Amendment Act of 2014. In response to the question posed by Commissioner Ngcukaitobi on the property equality and the referral to the government being in breach of promotion of property equality. Don't you think that because the government, through that act, wanted to go further in relation to the Restitution of Land Rights Act of 1994 by reopening the land claims from 2014 to 2019 was an attempt on the part of government to bridge the deficiencies in expediting land claims. And don't you think that those land claimants that lodged their claims between the 1st of July 2014 and July 2016 would then, in the face of that act being set aside, lose confidence in the ability of the Concord to promote justice for all, because the claims that they lodged were set aside because of the Concord judgment on Lamosa? Thank you.
Just, Commissioner, respectfully to start with the correction. The claims that were lodged were not set aside. They were recognized as having been validly lodged. And what the court did, though, is that they put them on ice. They said, we're going to hit the pause button, as the Commission must hit the pause button as far as those claims are concerned. And the reason that they did that is the terrible situation that we have in South Africa, where people who lodged their claims by the 31st of December 1998 were promised a right of restoration of their land. And tragically, the vast majority of those people are elderly people. The impact of intruding into the process, the 2014 now to 2016 claims, was to present the potential for still further delay. People have waited for close on 30 years to have their claims adjudicated. And I speak obviously in a partisan way because I was effectively representing those elderly claimants whose right to have their claims processed before they died was prejudiced by those new claims, as we called them. So I don't see that court judgment. If there's a proper understanding of what the court was trying to achieve, I don't see it as a basis for a loss of trust in the court. It was really an act to try and come to the assistance of realizing elderly people's constitutional rights, and to make sure that things were done in an appropriate sequence. They'd gone to the trouble of lodging their claims before the 31st of December 1998. They were elderly. They were entitled to be first in line. But the court didn't knock out the claims that had been lodged. No, it said the moment that the processing of the elderly claims has been completed, then processing can start. And there were also exception clauses in the order that the Constitutional Court formulated that said there's a particularly justifiable reason for somebody in that part category to come to court. You can approach the court and ask for relief.
Thank you, Advocate.
Thank you, Commissioner.
Thank you. No further questions. All right. We have reached the end of your interview, Advocate Dodson. Thank you very much for making yourself available and not giving up on us. Wishing you all the best.
Thank you, Chief Justice, and thank you to all of the commissioners for the hearing you gave me.
Is that rain? Someone sent me a message that they are getting hungry. So I don't know if we're still going. Are we still ready to take just one more? Okay.
So what did you say, Skip? How many minutes?
No, we will do that. Good afternoon, Justice Hussein.
Good afternoon, Chief Justice.
How are you? Are you well?
I am, thank you.
Good. Shall we start? Are you ready?
I am.
Okay. You are from my neck of the woods, from the Eastern Cape. You studied at the University of Cape Town. In 1984, obtained your BA, and in 1988, your LLB.
Yes.
Okay. And you worked for a spell. Was that as an intern, or was it a proper job as a researcher at the Researcher Center for African Studies?
Yes, for the Center for African Studies. I did a.
What did you do there? And why African Studies?
Yes, it was it was a project that was established, set up by the council of the university to look ahead at issues that were then referred to as Africanization. So I was involved with Professor Martin Hall and Professor Caroline White, and the research was to look at sort of post-colonial African societies and the process of transformation, Africanization of those universities, and what that would entail for UCT.
Right. Then you did articles.
Yes.
But didn't stay there. So you changed your mind almost immediately. You went to the bar.
I did, yes.
Okay. How long did you practice as an advocate?
So the articles, my articles were not initially registered by my principal. So I lost, I don't know, 8 or 9 months. When they were eventually registered shortly after that in early 1990, my principal decided to shut the practice, and she for a short while took up a position at the Legal Resources Center. I was initially keen to have my articles registered and transferred to another firm, but on reflection decided ultimately to go to.
You worked as the director of the investigative unit of the Truth and Reconciliation Commission.
Yes.
Between 1996 and 1997.
Correct.
And then went back to private practice.
Yes.
Okay. Where you remained until you joined the bench.
That's right.
But in 2011, you became appointed?
I beg your pardon?
When were you appointed as a judge?
2012.
But you started acting in 2011?
Yes, I'd acted for short periods of time from, I think, 2005 through until I commenced on the bench on the 1st of January 2012.
Mm-hmm. And how long did you remain in the High Court? When did you ascend to the Supreme Court of Appeal?
Yes, I was permanently appointed to the Supreme Court of Appeal beginning of December in 2022. Before that, I had acted for a total period of 18 months.
Mm. And you've acted at the Constitutional Court?
Yes, in the first 2 terms of this year.
Mm-hmm. How did you find that experience? How did it compare with with what you do at the SCA, if there's any difference at all.
Yes, I enjoyed the Constitutional Court enormously. It's a different work process in some respects. Obviously, there are fewer judges. So, I mean, the one aspect of the Supreme Court of Appeal is that you work in panels, and so when you're dealing with matters, you work very closely with those five judges. At the Constitutional Court, all of the matters are dealt with by all of the judges, applications as well as the hearings. But what I particularly enjoyed about the Constitutional Court was working in a chamber setup and working very closely with the law clerks within that chamber setup. It's something I've always enjoyed doing, is working with younger practitioners, and the opportunity to work with bright young clerks who are at the beginning of a career. I found that very rewarding.
You wrote 3 judgments at the Concord, not so, but not all of them have been delivered.
Yes, that's correct. Two of them have been delivered. The third one is in process. I think will be finalized fairly soon. I think there is a separate judgment that has now been prepared.
How many judgments would you say you've written in all from the High Court?
It's
maybe let's just look at, I know it would be many, let's just look at the reported ones.
I actually haven't counted, but over the number of years that I was there, I think generally speaking, I would end up writing about 15, sometimes 20, 25 judgments a year at least. So I would think it would be probably close to 200, maybe more.
During your legal career, you've also managed to produce articles on a wide range of legal issues. Did you do that in your capacity as an adjunct professor at Nelson Mandela University, or is just something you've done in your spare time?
Yes, no, mostly it's just as a matter of interest in trying to deal with, if you like, broader topics of value to the profession. So, I mean, the fact that I've been an adjunct professor at NMU, it wasn't a requirement that I should write. I have done some teaching and I've lectured at various points. But part of
which subjects have you taught?
Well, I taught when I was in practice, and then initially after I'd been elevated to the bench, I taught a selection course to final year law students on planning law, which happened to be an area where I had done quite a lot of work in practice.
Right. I interrupted you. You were still talking about these articles you've written. Or
No,
had you finished?
Yes, so as I was saying, it wasn't a requirement that I should write articles. Well, I think the faculty would probably enjoy it if I wrote more articles, because I think that they would earn some form of subsidy, if I'm not correct, if I'm not mistaken. So, but I have tried to offer back to the faculty as as much as I can, and part of that is to produce some academic work.
Okay. One of these articles you've written, you produced during the COVID-19 pandemic, and it's aptly titled COVID-19 and the Courts, Justice in Lockdown. And I have particular interest in it because I recall that when we were all scrambling around, not knowing what to do in the early days of the lockdown, I turned to you. I was still at the SCA then, and the advice, I don't know where you got the technological know-how, but the advice you gave me is maybe directly responsible for the success which the SCA enjoyed, in its output during that period. You just knew what to do. Where did you get this information? Did you do a course somewhere?
No, I haven't done a course. I think my children, and particularly my eldest son, would be probably quite surprised at this. He is the computer scientist in the family. No, the concern really, I mean, that initial thing arose straight after the hard lockdown was announced. There was no clarity as to what the courts were going to be doing. It was at the beginning of the High Court recess, and I was just immediately. I got onto the internet, as probably every single one of us did, whilst locked down at home, and tried to find out what was happening in other jurisdictions, and came across quite a significant amount of material. Try to read as widely as possible, and from that, I think I remember writing a short 2-page memo and sending it to my judge president at the time, saying, I think we need to do something along these lines. And the idea was to run motion court via Zoom. And so I asked if he would assign me to motion court duty for the remainder of the recess period, which he did. And that was because my thinking was, well, if you're assigned motion court duty, then you are seized with the role. And if you're seized with the role in the High Court, then you are entitled to issue, obviously within limits, some directions as to how you're going to deal with the matters. And it was from that we found a way of running motion court. And I think it was following that, possibly with the need to get the SCA and, of course, Constitutional Court up running that we spoke.
You are 63 years old, so that gives you another, about 7 years on the bench if you choose to stay.
Yes, I think it's just under 7 years. Yes.
Okay. All right. I'll leave it at that and hand over to my colleagues to put questions to you if they have any.
Thank you.
Professor Barumahai?
Thank you very much, CJ. Good afternoon, Judge Goosen.
Good afternoon, Professor.
I have 2 questions for you. The first question is in relation to your judgment that appears in page 137 of your pack.
Yes.
That was written in.
Sorry, 127.
137. 137.
Yes.
It is Mavundla and Kocha Security Services. It's one of the most recent ones that you penned in the Constitutional Code. This was an appeal, a labor matter, where Mr. Mavundla was trying to get some relief from the Constitutional Court. When I was reading the judgment, I see in paragraph 2 that the challenge at the CCMA was in terms of the Labor Relations Act, and the judgment is fact sort of dense, so it's very fact heavy. I could not make my mind as to which act was actually relied on to reach the conclusion that you reached in this case, because you start first by saying Mr. Mavundla relied on Section 23, in other words, on a constitutional route. But somewhere in the judgment, you say, in fact, you find that there are arguable points of law of general application, and it seems like you dispose the matter on those particular grounds. But it is not quite clear to me as to what are those particular arguable points of law and why Section 23 was actually not applicable in this. I'm not sure if you still remember the
Yes,
fact,
no,
maybe,
okay.
so that it's not unfair to you.
Yeah.
But you get the sense of where my question is going.
No. I think I understand the
Yes.
question. It's really the question of what jurisdiction was being exercised, whether it's constitutional jurisdiction or
Yes, that's the
general
essence of my
jurisdiction.
question.
I think, and I mean, I've looked at it, but I will look again. But my the conclusion was really it's a labor-related matter, and that in this case clearly implicates labor rights conferred in terms of the Labor Relations Act, and that would be sufficient to establish constitutional jurisdiction, and that it may also be even outside of that a matter of general jurisdiction. I'm just trying to find a specific paragraph in the judgment where I think I deal with that. Yes, I think it's paragraph.
It might be
24.
paragraph 25 also.
20,
Maybe it might
24
assist.
and 25. Yes. Indeed. So I say it engages the court's constitutional jurisdiction, which is really the essential basis. But there was also an argument put up that it implicated the general jurisdiction because of the arguable point of law. So notionally, yes, but the matter is really disposed of on the basis that we enjoyed constitutional jurisdiction.
Let me ask you more, as a follow-up on that question. We know that the Constitutional Court has this broader jurisdictional ground upon which people can actually approach it. It seems to me that there has not yet been clear guidelines as to what actually entails this arguable point of general public importance. And I take the point that there have been judgments that have tried to give an indication that perhaps maybe if the issue is only fact related and does not raise points of law, I understand that. But I think between me and you, we know that sometimes there can be a conflation between facts and law. And it's not a really clear-cut situation as to say, these are the points of law and these are the factual issues. What is the actual criteria that the Constitutional Court actually uses to determine that this particular case can be entertained because it engages this leg of the jurisdiction?
You ask a difficult question because you're quite correct, I think, Professor, that the jurisprudence is perhaps still developing, and one can read some of the judgments. Paulson, Slipknot, that judgment, which is really the one that sets it out most most clearly. But in subsequent judgments, I do think that the criteria haven't always strictly been spelt out as to what would constitute completely an arguable point of law. And there is a measure of flexibility in the application of that test, which does make it difficult from time to time to follow exactly what the basis is. I think it is often also the case that it's difficult to distinguish a matter that would be purely and simply a matter of general jurisdiction, as opposed to and having absolutely no constitutional implications whatsoever. Because matters of general public importance, where interests of justice come into play, may touch upon, and in fact at times do impinge upon, broader questions of the application of the court's constitutional jurisdiction. So I agree with you that I think it's not an area that is yet finally clarified, and it's an area where there is certainly scope for, if you like, more nuanced development.
Thank you, Judge Gustin. My actual second question is, there is a written case that was heard. You know, the beauty about the Constitutional Court nowadays is that most of the hearings appear on social media, so you can follow them in real time, right? There is a written case that was heard by the Constitutional Court. It's the rent manipulation case. That's what I call it, where there was issues about rent manipulation, cartels, and all those kind of things. But I'm not going to ask you about the actual case. What came out from that case? It painted a very unfortunate picture, in my view, which is still persisting even today. It appeared to me that most of the counsel that appear in the Constitutional Court are actually white, and white males in particular. And you'll find sometimes white females, and you'll find the usual black counsel that appear in that court. And it seems to me that the issue of briefing, it keeps on recycling itself. The bench is black, the bar is white, perpetually. Is the Constitutional Court as an institution, or does the Constitutional Court as an institution have a role to play in trying to change these briefing patterns where black, and we have a lot of black competent advocates who are not given a chance to appear in the Constitutional Court? What can be done to change the mindset and to say, can we please be in South Africa and grant opportunities to these competent black people?
Yes, thank you. Again, it's a difficult question. Difficult because I think generally the courts, whether in the High Court, Supreme Court of Appeal, or at the Constitutional Court, the courts really have a limited role, or there's limited scope for the courts directly to impact changes or require changes in briefing patterns. And that's simply because the courts, they are engaged by the parties at a stage when attorneys or counsel have already been briefed. They're the ones that bring the court. So engagement at that level, I think there's possibly limited scope. There's undoubtedly scope for, if you like, at the level of public public expression of the need for thoroughgoing transformation within the legal profession, for judges in their public presentations, whether it's by way of lectures or talks or elsewhere, to offer and lend their voices in support of that process. As far as the Constitutional Court is concerned, I think slightly different. It's not an immediate direct impact on those briefing patterns, but I think if you look carefully at the contribution that the Constitutional Court has made to the empowerment of young practitioners, the clerking system has been an enormous fillip for transformation within the profession. By far the majority of clerks, certainly that's been my experience, most recently seeing who was there, but certainly over the years, the clerks who've been appointed, many women, many black practitioners who have gone on to make significant contributions within the profession. And I think that's a direct contribution that the Constitutional Court does make. So it's that training, mentoring, making available skills, if you like, ultimately. But it remains a difficult challenge, where, if you like, a particular expertise is still within the control of maybe a relatively few practitioners.
Thank you very much, Judge Kutzen. Thank you, CJ.
You keep. That's not how it works, though. I pick the first hand I see. It has nothing to do with seniority. But go ahead, Minister.
And thanks, Advocate Ngoto. Yeah, we seem to have correlated. Thank you very much. Good afternoon, Judge Hossan.
Good afternoon.
And thank you very much for your reflection. And if I can correctly, and you'll correct me if I'm wrong, what you just reflected now, you gave an impression, an indication that in relation to transformation, because you speak into briefing patterns and others, that you acknowledging that we not have done so much that we should have. And I hope I'm correct in listening to how you just summarized. And this brings me to your article that you wrote, I think in 1989, the debate over Africanism, Africanization and the position of women. And I can hear those articulations still coming through, because in terms of the issues that you are reflecting, yes, noting that the court might not have a direct impact and work to do, or even the Constitutional Court in terms of transformation, but given your views then and what you are reflecting today, what do you think we need to do to change the status quo? Because you're clearly saying to us that if we could have different briefing patterns, we'll see. I think if I heard you correctly, and if maybe I did, you'll correct me. The issues, even how the SOC comes through in terms of previously disadvantaged individuals from where we're sitting. Maybe if you can share some views and ideas, what is it that we need to do? Because as much as you'd be a Constitutional Court judge, we do not want to see the values and the principles of the Constitution that we so follow and believe in not being reflective of our society. And therefore, those who appear before you as a judge would definitely have to reflect what we have as a South African society and actually show that equality within our courts.
Yes, indeed. Some of the suggestions I would put up, or views I would express, are of course, and they must be read against the fact that I've not, been a judge now for for a number of years, and so I'm not engaged, if you like, in the hurly-burly of practice and at the bar, where I think that's really where the primary responsibility would need to rest. That professional bodies like the Bar, Advocates for Transformation, the BLA, General Council of the Bar, and other organizations are engaging in, if you like, far more practical steps. I'm not suggesting they're not, but very practical steps to build a culture of mentoring amongst practitioners, and to ensure that those skills transfers are happening effectively. That's on the one hand. But in terms of briefing patterns, I mean, that's the decision that's generally taken by an attorney or a firm of attorneys to brief particular counsel involved in arguing a matter. And I think those briefing patterns, really there, we need to be addressing those firms and in ways that are like maybe more persuasive, more direct in a way. So you have to engage in a programmatic commitment to shifting patterns of briefing, because if you don't do that, really what you're doing is you're limiting the scope for the reproduction of a effective, independent bar that can thrive in this constitutional democracy. So we really need to be placing that emphasis on where those decisions are taken. I know, for example, and this is just that within the state attorney, there are, I mean, really from when I was practicing, quite different briefing systems that now apply. My impression from the outside is that it is having a positive effect. It may not be enough, but there's undoubtedly a need to strengthen those initiatives as far as we possibly can within the profession.
So in terms of within the judiciary itself, having been the judge, the acting appointments of judges, in my view, does provide an opportunity as part of those who would gain experience as we talk about skills transfer, access to opportunity to be able to be sitting on the bench and deal with complex matters that might not come to you as an advocate. What do you think should be done within that system to be able to increase the opportunities for those who are previously disadvantaged to be able to have access to those opportunities as part of transformation? Should we have a framework that needs to be coming into place, or should we be just continue? So I'm trying to see whether you think that could be another tool that we utilize, and how effective can we utilize that tool?
Well, I think there's no doubt that giving practitioners the opportunity to serve as acting judges it does an enormous amount for the development of those practitioners. And my own experience, and I think this is probably true of most acting appointments, is that you come away from a period on the bench with perhaps a slightly different view of how matters are run, and your level of experience, because you're exposed to a range of different matters which you may not have been in practice, that certainly is is a positive thing. The largely acting appointments really fall within the ambit of authority of the head of that court, and I'm not aware of how those systems always work. Sometimes they work slightly differently in different divisions. But it does seem to me that the judges president of the divisions are very conscious about the fact that they're needing to find and develop talent that can be appointed to the bench. Having said that, I think it is also important to understand that, I mean, the primary responsibility when one's dealing with filling temporary vacancies on the bench is that the judicial work is done, so that it may not be a primary function of mentoring and training practitioners. It has that spin-off effect. I don't know whether a framework. I know that there've been discussions at in some divisions, for example, about trying to work out, what types of criteria should apply in inviting people to act. I'm not aware of any developed framework at this stage, and it may be that that's something that the heads of court could pay some attention to.
Commissioner Trolley?
Oh, okay. I think I can skip it. CJ, can I make a follow-up on this question?
Sorry, is that you?
Yes.
All right.
Justice, how are you?
I'm fine, thank you.
I don't know whether I missed it somewhere, Justice. I didn't get you exactly as to you as an individual.
Yes.
During your time as a legal practitioner and even now, what is it exactly that you have done to support the cause of transformation?
Yes, thank you for the question. I think it's clarified in point form the sorts of roles that I fulfilled when I was at the bar. I was very directly involved in the pupillage program, and both at the local bar in the Eastern Cape, ultimately was involved in directing the national pupillage program for the bar. And that involved trying to get a standardized system of tutoring and lecturing and so on happening at each of the bars. We had a very full curriculum and material to go along with it to assist pupils. I was also involved in advocacy training, again through the General Council of the Bar, so specifically running programs for teaching advocacy skills to pupils and young practitioners, and even at an advanced level. Within my practice, I tried to engage young practitioners as juniors, assisting them as far as possible. I think that, and if you read the Advocates for Transformation comment, which was submitted, it highlights a range of that type of activity that I committed to throughout my time at the bar.
And perhaps I should just go back one step and do something I omitted to do when I was leading you earlier, that your work towards transforming South African society is said to go back to your early days, and one guessed this from Nadel, which one of your nominees, and former President Mpati, and the GCB, which has commented on your candidature, and they tell a story of a young man, a young white man who was a vigorous political activist. Among his exploits, defying his military call to serve up in the defense force of the apartheid regime, campaigning against compulsory military conscription during apartheid, representing activists who were prosecuted for their opposition to the apartheid regime, communicating with communities about the state of emergency while representing detainees, and that you were involved in the ANC, you were in the executive committee of the United Democratic Front, and you represented the widows of the Craddock Four. You were deeply involved in the work of the liberation movement, and that spilled over to your legal career when.
Yes.
I should have done that earlier.
Thank you.
So your stripes in that respect are unquestionable.
Thank you, Chief Justice.
Commissioner Jivan.
Thank you, Chief Justice. Judge Ghost,
sorry.
As practitioners, we are faced with time constraints all the time. Even before we instituted action, we've got to see whether we actually have met any time constraints prior to instituting the action. I see that the judgment that you've attached to your papers on page 104 was heard on the 23rd of November and was delivered on the 27th of May the next year, which is a lapse of some 7 months. That's a concern to me as a practitioner. And what's the average period of your handing on your judgments, and how do you think that we can better the situation to get courts to hand down judgments more speedily for the betterment of the litigants and all concerned?
Yes.
Thank you.
Yes, thank you for the question. I've not worked out what the average period is. I'm pretty diligent. I think the comments of the law bodies too point to that. I try to get my judgments out as rapidly as I possibly can. It's not always possible to do that. But I do think I am relatively prompt in getting judgments out. I think in the case of Botha, yes, I think the judgment was delivered in May. It was heard in November, but there was in fact in that judgment a dissenting judgment. Former Justice of Deputy President Petse at the time. So, the procedure is that the scribe, I was the scribe, you will write your judgment, circulate it, and there will be an engagement. Obviously, if there's going to be a dissent or a concurrence, then one has to wait until that concurrence comes through. And only once it comes through can you finalize the delivery of the judgment. And again, I really don't want to criticize Justice Petse at all, not at all. He was, as deputy, extremely busy. But that would have been a reason for the slightly longer period that it would have taken, the time to get the dissent in and finalize and then hand it on.
I understand. Thank you. Just the second part of my question,
yes,
then is that we as practitioners, and we've got a public, remember, we've got a public that's well educated because of all the technology tools that are available to them. It's a different public compared to when we didn't have this wide internet dispensation of information. Now, as practitioners, we've got to tell them that, look, why is it taking, the questions we usually face is, why is our case taking so long? Why aren't you progressing my case? So we are in the situation where all we can say is it's in court and we're waiting for judgments or something like that.
Yes.
So the second part of my question is,
Yes.
how can we streamline judges and all the courts for that matter, all the high courts, and goes down even to the magistrate court level, where we can get them to deliver judgments speedily, and hence create a better impression of the law to the public we serve.
Yes, thank you. Forgive me for not answering the second part of the question initially, and for drawing that to my attention. Practitioners, I think, are in an invidious position. Your hands are tied in the sense when you're having to deal with the court respectfully. You're not wanting to be perceived in any way to be badgering the court, considering a judgment and handing it down. So I fully understand the dilemma that practitioners face, because you've got to answer to your client. I think the broad framework of the code of conduct and requiring that judgments are delivered within a period of 3 months at the latest is an attempt to deal with that difficulty. But the mechanism, I think, and maybe this is the thrust of the question, the suggestion from my side, is that it may be necessary to develop a protocol by which practitioners can engage with the bench that heard the matter, possibly even prior to the 3-month period, to obtain a clearer idea of when the judgment is likely to happen. And I say a protocol or a framework because you as practitioners might need to be protected from the accusation that you're badgering the bench unnecessarily. Again, that may be something that, as between the practitioners and the heads of court, is something that might be considered a way in which you can obtain better feedback, more valuable feedback about the process by which a judgment is being prepared and what might be reasons for a delay. For instance, in this instance, I mean, we would generally not disclose to the public out there, well, there's a difference of opinion in this matter, and that's why it's taking a bit longer, because I don't think that that's appropriate. But at least you could get some indication that there is a delay for ABC reason. That may be something to consider.
Thank you, Judge.
Apologies to you, Commissioner Trollip. I mistook his hand as a follow-up question. I do have follow-up questions, though, from Commissioner Baloyi and Commissioners Baloyi and Nkaitobi. You pass? Okay. Commissioner Trollip.
Okay, what about, all right. Anyway, carry on, Commissioner Trollip. I don't think you've spoken for the whole morning.
No, I haven't spoken once this morning. It must be my turn. Thank you very much, Chief Justice. Thank you, Judge Wilson. I'm partly covered by Commissioner Shabangu and what the Chief Justice mentioned around your commitment to transformation. It's generally agreed and accepted that you and I come from advantaged backgrounds. And some people are often blind to that. And I noted in your application that the extensive commendations, individual and from organizations, around your commitment to transformation in word and deed. And I was just wondering whether you could tell us where that commitment comes from, what incubated it and what has sustained it.
Yes, thank you, Commissioner Trollip. So I grew up in first formative years in a sort of working class suburb of Port Elizabeth. And my parents weren't particularly well off, but I was fortunate, despite that, to attend a private Catholic school, Marist Brothers College in Port Elizabeth, which is now since closed down. And my parents struggled to keep me in the school just because it was a private school. The fees were different to those that applied at the time to public schools. But I was able to access that education precisely because I was growing up in a white, privileged society where access to education was skewed, subsidies were provided to schools on an entirely different basis. So, I'm very conscious that that's the case. But it was at that school where I was exposed to, and very fortunate to be exposed to, I suppose, more progressive way of looking at the world. I mean, two things happened in 1977, when Steve Biko was murdered in detention. He had been held at the Warmer police station. The Warmer police station was directly alongside a supermarket, OK Bazaars, where my mother worked. I used to go there afternoons after school to wait to get a lift home. So I was very familiar with that area. I'd spend a lot of time, in fact, at the library, which was directly opposite Warmer police station. So when news broke about Biko's murder in detention and the fact that he'd been held at Warmer police station, I mean, that was, for me, that was like a profound shock to my system. That this could be happening literally across the road from where I spent quite a lot of time in the library. I was fortunate at the school to have a history teacher who gave me a copy of the Freedom Charter when I was 15 years old, told me about the Congress of the People. Also told me I should not tell anyone else about it for good reason. So, those sort of things change your life in a way. You begin to get a sense that different things are happening all around you that you are not necessarily immediately aware of. In 1978, I was taken by I would call him a radical priest. He was involved in young Christian workers in Port Elizabeth. Himself had been detained several times. But he took me into the townships of Port Elizabeth, into New Brighton, Zwede, to the northern areas. I met young activists. I met some of the activists who in 1979, a year later, established COSAS. So, that was the privilege that I had. And it came from where I was in my circumstances. So that was the incubation. I was never going to not be concerned with social justice, having had that experience. And so I tried when I went to university, and subsequently have tried to apply my the privilege of a good education to make a difference as far as I could.
Thank you.
Okay. Commissioner Mkhwanazi?
Thank you, Chief Justice. Well, you will be glad, Judge Khosa, to know that Steve Biko's inquest has been reopened by this minister sitting here. I wanted to ask you about the question on transformation and what role judges might play. Your answer, as I understand, is that your hands are tied as a judge.
Not quite. Yes, partly. But let me hear the rest of the question.
All right. I want to give you one example. The Chief Justice of England and Wales issued a practice directive in 2023. I'm not sure if you're familiar with it, in which she specifically said women advocates or barristers do not appear frequently in the Supreme Court. Yet they play a meaningful role in the preparation of argument and papers. But the glory as such is taken by the men who appear in court. And in that practice directive, she said that when a female candidate, a female barrister, has been intimately involved in the matter, they should be given a portion to argue, and gave the rights to the judges to issue their own practice directive on a matter-by-matter basis, in which they make a similar directive. Now it's 2025, I don't know the impact of that directive, but that came from the Chief Justice of England and Wales, illustrating that we sometimes complicate the problem of transformation and the role that judges can play. One of the unique features of the Supreme Court of Appeal is that most of the people who speak there, who open their mouths, are men.
Yes.
And the president of that court could issue a directive saying, I want to see more women speaking. If you are arguing a matter on eviction, I want maybe section 4 to be addressed by a female junior who is there sitting in court and watching. So what is the reason why our judges have taken such a conservative view on intervening to redress the problem of transformation? I mean, Judge Mota has been sort of seen as an outlier when he said, I refuse to have white men speak in my court. I want to see more diversity.
Thank you. Thank you for the question. Yes, just to correct, you're right. When I answered the question, that I was suggesting that perhaps there's limited intervention that we can make as judges. But the example that you give, I think, is a good one. There is no reason why, and maybe this is particularly in appellate courts, where one often has more than one counsel involved in matters for the parties. There is no reason why something along the lines of a practice directive, which requires that the parties make use, if you like, of the full panoply of counsel in the presentation of argument. That certainly, I think, is something that one can look at. Why are judges reluctant to do that? It's difficult for me to answer that question in this sense. That yes, we can, when you're presiding in a matter, particularly at a trial court level, you are the director of the process and proceedings. So from a high court level, yes, perhaps there is a need for judges to be a little bit more interventionist in how the presentation of matters is dealt with. Presiding judges in the appellate courts, of course, could do similarly. But at a systemic level, I think the idea that one could regulate the presentation of argument in the appellate courts is certainly something that one can look at. I'm not sure, and I haven't considered whether it's the sort of directive that would fit in with the sort of general powers of issuing directives as far as the Superior Courts Act is concerned. Offhand, I can't think of a reason why not.
Yes, and it might be better for the judges that the person who drafted the papers argues the case.
Yes.
So that when you ask, where is point X, they know exactly where to find it. Yeah. They don't look back.
No, correct.
Yes. Now, I want to ask you about your philosophy because you are now going to the Constitutional Court. In a sense, I'm familiar with your philosophy, having appeared a number of times in your court. If you recall the case of Mazodzo versus MEC for Education, in which you interpreted Section 29(1)A of the Constitution as imposing a directly enforceable right on the part of parents of children to demand the delivery of textbooks. Sorry, it was desks and chairs. Yes, yes, but following from the Section 27 case on textbooks.
Yes.
Do you think that approach should apply also to Section 26 and Section 27, and that we should perhaps jettison the reasonableness approach in the light of the prevailing levels of inequality, despite a constitution that promises to end inequality?
Yeah, I suppose the first challenge there is that one would have to deal with sort of jurisprudentially, philosophically, if you like, is the way in which those sections are framed. The sort of more, that they're it is less about the imposition of an immediate and as opposed to the education requirement. But notionally, no. I think there is no reason why one could not adopt a more robust approach to those sections. I mean, that's certainly been the case as far as housing is concerned, and you will know the sort of arguments that occurred following the Grootboom judgment as to whether it had gone far enough and how that should be interpreted. There is undoubtedly scope for that development. I mean, this is the beauty about the Constitution, is that it is not fixed in its interpretation and application. It deals with context, and this is social and economic context is always relevant. So notionally, yes.
Yes, I'm glad you're mentioning Grootboom. If you ran a case today against the city of Cape Town on the same facts, do you think you would give the same judgment, or would you now tell them it's actually time to put houses?
Well, I think that there's certainly been some jurisprudential development around those issues since Grootboom. And I think that, it's difficult to say whether I would adopt a different approach. Quite possibly.
No, I mean, my problem, Judge, is this. If you told the city of Cape Town in 2000, which is when Grootboom was decided, that they need a plan that would withstand reasonableness, and then you came back to court in 2025 against the same city, and they still haven't delivered houses because Mrs. Grootboom died without a house.
Yes.
I mean, surely the Constitution doesn't mean you must now tell them, develop another plan, a second plan.
No, that I accept. Yeah.
Thank you, Chief Justice.
Commissioners Baloyi and Pillay.
Thank you,
Your
CJ.
follow-up questions.
Yes. Good afternoon, Judge Person. This is it's really a follow-up on the first point and that's the transformation conversation. And I guess intervening at this point now, it's more hopefully to encourage, hoping that it encourages less reticence on the part of the judiciary, this intervention that I'm making now. And it's really this, that the idea, perhaps what we need to do is to reframe as the judiciary, to reframe the conversation about the lack of transformation and the change of briefing patterns, and see it as an issue about the future bench, because and less about changing briefing patterns for Commissioner Ngcukaitobi's economic equality concerns, but about the future of the bench, because you are going to retire, and I would like to know that the sitting judges today are concerned about who replaces them. And as matters stand now, with the briefing patterns as they are, you look at the bench in maybe even the Constitutional Court, the Competition Appeal Court. You look at those courts, it's pretty much predictable what it looks like 5 years hence, what it looks like 10 years hence. It will still be populated by the same demographic, because it is the demographic that keeps reproducing through experience in that court. So I make this intervention to urge that perhaps the judiciary needs to look at this question of transformation and changing briefing patterns differently from their perspective. What bench do you want to see 10 years hence? Thank you.
Yes, thank you, Commissioner Baloyi. I think you raise a very important point about how one begins to frame and reframe the discussion about transformation of both the profession and the judiciary. When you refer to, if you like, the future composition of the bench, I think what we need to grapple with is that there are systemic challenges that I think beset the judiciary still. Judges who are appointed to the Supreme Court of Appeal are judges who come from the High Court. It's not always the case, but judges who are appointed to the Constitutional Court, certainly over recent years, for the most part, have been judges who've come from the Supreme Court of Appeal. So if one is struggling with demographic transformation of the judiciary at those levels, that speaks to a systemic problem in the appointment of judges to those courts. So yes, I think the judiciary needs to be conceptualizing where it wants to be, what it wants to be in the future, and how it wants to get there. I think that's important. But equally, I think this commission it needs to be examining, perhaps reviewing and evaluating how it has succeeded, the extent to which it succeeded in providing for systemic transformation of the judiciary through the appointments that it has made. Of course, you can only appoint people who make themselves available and maybe are judged to have sufficient experience or exposure or the like. And that's where the responsibility then, primary responsibility would fall on the profession. I think increasingly the profession needs to be saying what type of judiciary do we want for a democratic South Africa, and how do we get there? And what do we need to do to get there?
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Judge Wilson.
Good afternoon.
In the latter part of your answer, Judge Hussain, you went exactly where I wanted to take you, which is to shift the focus from judicially driven transformation and take it back to the professions. You very usefully said earlier in your interview that we needed tools or methods of persuasion to try and get the firms to improve their briefing patterns. And I wanted just to understand your assessment of the situation. Why is it that you think the firms are resistant to briefing Black and women advocates?
Look, that's very difficult to, it's really a broad speculation, but I think we can't deny the fact that deep ingrained socialized perceptions that come out of a gendered and patriarchal society permeate every level of the society. So, you know, whether that's the main driver, you know, I can't say, but my guess is that that's what we're looking at. And how one changes those attitudes, how one deals with that. I mean, I think we know that that's it's a very substantial social transformation challenge that we face. But you know, I mean, there is an elephant in the room in those circumstances that needs to be addressed. How precisely one does that, that's difficult. I don't have a ready answer, but I think that's what we're looking at there. I mean, we come from a deeply gendered and patriarchal cultural milieu that persists.
And it's only once we grapple with the elephant in the room that we can arrive at the tools of persuasion.
Sorry, could you repeat that? I didn't.
No, I'm saying it's only once we grapple with what you described as the elephant in the room that we can then try and identify what are the available tools of persuasion.
Yes, I agree. Yeah.
Thank you, Judge Hussain.
Thank you.
Commissioner Matolo-Dleku.
Thank you, CJ. I just want to follow up on what Advocate Pillay is raising. You know, Judge Hussain, we have a legal sector code now, but we still have the very resistant when people don't want, they're actually challenging it. But sadly, we tend to look at government only, but the main culprit is being the private sector. And one of the issues that I always ask myself is that because this is where complex work come from the private sector. And the same government is doing work with private sector. Surely there must be a stick from government to say, if you are not going to transform, we won't be doing business with you. Don't you think it's a fair assessment?
Yes, the precise mechanism by which that occurs, of course, is you know, may give rise to all sorts of probably quite difficult questions to address. But I certainly agree that this is not a problem confined to the public sector by no means. And getting buy-in and getting into the private sector and commitment from business and various other private sector entities is really where some focus would need to be applied. How one does that, of course, again, these are not they're not necessarily simple interventions that can be made. I mean, I firmly believe in the transformative power of law. Well, I wouldn't be sitting here if I didn't believe that. So legal frameworks, regulation, those sort of things are clearly, those are mechanisms by which one can achieve a process of change.
Thank you. Thank you so much. Let me once again extend warm greetings to all of you. And as a way to resume the proceedings, explain to the members of the media who have been with us since this morning, and it might have been unkind for us to have requested you to give us time to do our housekeeping the way we did. We must explain to you, or we must inform you what we were doing when we requested you to go out, because it's important that you must know. We had to deal with housekeeping issues here. Before you were released, there were issues that were validly raised by members of parliament, members of this committee, regarding the statement that was presented before this committee and before yourselves. Its quality had to be enhanced to meet the standard that the committee has set. And at the time we requested you to recuse us was because we wanted to satisfy ourselves that whatever product that will be presented here before you for the purpose of resuming the proceedings is exactly that. So the senior counsel has consulted with the general, and they are satisfied that the document that they are presenting before the ad hoc committee, which will also be circulated to yourself, is in accordance with our expectations. So I want to welcome you back again, General Nhlanhla Mkhwanazi, and thank you for your patience and your cooperation. I'm going to take this opportunity and give it to the senior counsel to present this statement that has been revamped.
Thank you, Honourable Chair, and honourable members of the committee, and to everyone present, and to the people and media. Apologies from our side. the evidence presenters for the delay and the inconvenience caused, and we also thank the General for his patience and his cooperation. And thank you for the opportunity to meet with him again, to consider and to consult about some of the issues that were raised before the adjournment. We have amended the statement, the original statement, by deleting reference to initial and supplementary, deleting that, and also at the old paragraph 8, we've amended it to read as follows. I consulted with the committee's evidence leaders on 25 and 26 September 2025. This is my statement to the committee in response to the terms of reference, where I deal with certain factual matters canvassed in Annexure NSM 3, which is the statement made before the Nhlanhla Commission. I include those details as an annexure to this statement. My statement, as well as the annexures included in volumes 2 and 3 of my witness bundle, encompass all my evidence before this committee. So, Chair, I respectfully submit that the concerns, the issues that have been raised have been fixed, cured, in consultation with General Mkhwanazi, and I would respectfully request that you swear him in so that we can commence to lead his evidence in accordance with his statement.
Okay. Thank you so much. I think what I should do, because you have now formally presented the statement, let me rotate between the members before we administer oath. The report that you present here is a report that the members have directed. So it will be fair that I give them an opportunity to impress on it. I'm starting with the rotation.
Thank you. Thank you very much, Honorable Chairperson. Let me thank the evidence leader as well. The African National Congress is satisfied at the reading that the issues that we had identified as defects of this statement, being a supplementary statement, do seem to have been cured, as the evidence leader says. We trust that with thorough reading of the document, indeed, that will be confirmed. So we're happy to proceed. Thank you, Chair.
Thank you so much, Honorable Sango and Honorable Nombalo.
Thank you very much, Chair. Chair, we are noting the amendments that have been made, and in our view, they have been made in accordance with the instructions of this committee. So we can't postpone this any further. South Africans want to hear the General testifying before this committee. So here is an opportunity, and we can't postpone. Let the work of the committee start now.
Honorable Skosana.
Thank you, Chair. There's a small matter which we wish to put it on record. And I want to thank the evidence leader. Though it is regrettable that the senior counsel chose to open with a preamble in the morning, presenting personal opinion, as thought they were established fact and citing matters of the Zondo Commission or the so-called State Capture Commission that remain contested and currently under judicial review. This committee, this ad hoc committee, in the interest of procedural progress, exercise restraint and refrain from challenging these assertions. Even more concerning, Chair, is that the senior counsel apparently disregard for this constitutional separation of power between the executive and Parliament, a principle essentially to the integrity of these proceedings. Such conduct is if left unchecked, risk of undermining this committee work and setting the unfortunate precedent for the future engagements. Accordingly, the committee must be careful and consider whether the time spent under these circumstances should be treated as billable and what measures, if any, are appropriate to ensure the adherence to Parliament protocol going forward. And I wish to thank as well you, Chair, of handling this matter with caution and with the sensitivity it deserves. And I wish to thank the Provincial Commissioner General Mkhwanazi for him to be still with us. I thank you, Chair.
Thank you so much. The Democratic Alliance.
Thank you, Chair. We've gone over it and everything looks fine as was proposed. So it's fine from our side. We can proceed. Thank you, Chair.
Thank you so much. The Economic Freedom Fighters.
Let's proceed, Chair.
Thank you so much, Mukhalaka. The IFP.
Well, thank you, Honorable Chair. I think we can proceed. We're satisfied with the amendments. Thank you.
Thank you so much, Honorable Mango. The Patriotic Alliance.
Satisfied, Chair. Thank you.
Thank you so much, honorable members. We have rounded all the members of the committee, and the strongest feeling is that we should proceed. The next item will be to administer oath on General Mkhwanazi. Before we do that, we must put it on record. Earlier this morning, I informed you that the full member of the Democratic Alliance to this ad hoc committee, the full members are Honorable Cameron and Honorable Breitenbach. So Honorable Breitenbach, Honorable Malema and I are members of the Judicial Service Commission, and it is sitting today for the next 10 days. So the reason why Honorable Breitenbach is not here is because she's at the JSC together with the other parliamentary designates there. So the Speaker of Parliament has accordingly informed the Chief Justice about the number of the members of Parliament who will be available for the work of the JSC. And the two of us, Honorable Malema and myself, who are here, why we are unable to be at the JSC for the duration of the October interview. So I just felt I should put that on record so that honorable members and the media should know why Honorable Breitenbach is not here. And so the alternate member for the DA is Honorable Diane Kolabanat, who is standing in here for Honorable Breitenbach. Thank you so much. Let me move to administer oath on Lieutenant General Nhlanhla Mkhwanazi, the Provincial Commissioner of the Police in the KwaZulu-Natal province of the Republic of South Africa. Lieutenant General Nhlanhla Mkhwanazi, you have been invited to appear before the ad hoc committee to investigate the allegations that you have made, to provide information to the committee's oversight so that it can properly investigate the allegations that have been made, which include, amongst others, the alleged unlawful disbandment of the political killing task force or team, which is known as PKTT, alleged moratorium on the filling of vacancies within the South African Police Services, SAPS, and alleged corrupt relationship between senior leadership within the SAPS and members of the public, as well as political interference in the work of the SAPS. In extending this invitation, the ad hoc committee chairperson has indicated that you may provide such information to the committee, if you so wish, under oath in terms of the powers, privileges and immunities of Parliament and Provincial Legislatures Act. You have indicated that you wish to take the oath so as to be afforded the protections as provided in the Powers and Privileges Act 2004. Please be informed that by law, you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or a committee of Parliament may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware that in terms of Section 17, subsection 2 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes a House or a committee with information or makes a statement before it which is false or misleading, commits an offense and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are required to take an oath or affirm that the evidence you are about to give is truthful. You may choose to take the oath or the affirmation, and then I will check with you, General Mkhwanazi, if you choose to take oath or affirmation.
I'll take an oath, sir.
Then if you take an oath, you will then have to repeat after what I say, respectfully so. I am going to read the oath. So where I say I, you will then have to mention your names, because the I in this case, because it's me reading, will be referring to Malapi Soviet Lhanyana. So in your case, you will say I, Nhlanhla Mkhwanazi. I swear that the evidence I shall give. May you please repeat after me, General Mkhwanazi, or do you want me to read the whole?
I can say all of it, Chair, if you want me.
Okay, no, it's fine. So
I, Nhlanhla Mkhwanazi, swear that evidence I shall give shall be the truth, the whole truth, nothing else but the truth, so help me God.
Thank you so much. Honorable members, here we are. I want to thank you, General, for this exercise. Are we ready, Senior Counsel? Because I'm now handing over to you to lead us.
Thank you. Thank you, Honorable Chair, honorable members. We're ready to proceed.
Thank you so much. Over to you.
Thank you. Good afternoon, General.
Good afternoon, sir.
And thank you again for your willingness to cooperate with us and to spend some time with us. drafting your statement. Are you satisfied that the statement, together with the annexures referred to in your statement, is your statement that you make under oath, and that you are personally comfortable with it to swear to this is the truth?
Yes, I am.
Thank you. Now, we know why we are here. It arises from the media briefing you held on the 6th of July, and that is referenced at paragraph 3 of your statement. And at paragraph 4, there's a reference to the fact that this ad hoc committee established by Parliament had asked you to present to it in accordance with its terms of reference, which you see, and that was on the 22nd of August this year. And the terms of reference, the relevant or the key areas are referenced at paragraph 6 and at paragraphs 4.1.1 to 4.1.18, which is on page 6. Is there anything in those terms of reference that you want to highlight? We are going to deal with some aspects of it relating to your evidence, but you've seen that and you're familiar with those terms of reference. Is that correct?
That's correct.
Thank you. Now, you have consulted with us. We spent a considerable time putting together this statement. And the annexes are at volumes 2 and 3, which I see it's either on your soft copy of your computer or hard copy on your left, and we'll make occasional reference to some of those annexures. However, could you, just for the record, it's at paragraphs 9.1 to 9.6, just describe to us your position currently, as well as the previous years you've spent in the South African Police Service as a police officer.
Honorable Chair and honorable members, although I did not want to bore the members with the history since I joined the service, which was in 1993, but I felt it's important maybe to reflect the position I held as a senior manager in the organization in the top executive of the SAPS, which started in 2011, that I performed the task as the acting national commissioner at the rank of a lieutenant general in 2011-2012. And subsequent to that, I had the privilege of not working for a year, but still employed in the police. And a year later, I was then assigned a division facility management as a divisional commissioner there. And after that, I was then appointed as a divisional commissioner of human resource development. And after human resource development, I became the acting provincial commissioner KwaZulu-Natal. And subsequent to that, I moved to the division operational response. And then I went back to KwaZulu-Natal as a provincial commissioner on a permanent basis, which a position that I'm still occupying until now.
So your movement up the ranks has been quite extraordinary over the years. You rank as one of our most senior police officers, and you are familiar with all the workings within, especially senior police management. Would it be fair to make that statement?
That is correct. I'm a member of the Board of Commissioners in the South African Police Service, which is the top structure of the SAPS.
You also acted as the National Commissioner in 2011 to 2012.
That is correct.
That's correct. The main reason why we are here, it relates to the issue surrounding the political killings task team. So perhaps we could just start by looking at the establishment of that, let's call it the PKTT, when, for what purpose, and how it operates, and perhaps start in 2018. We know that in this chamber, not exactly the same chamber, but in Parliament, President Ramaphosa had made an announcement of the formation of an interministerial committee in this House, and that had been set up to look into the political killings of KZN. Just talk to us about that development and what happened subsequently.
Thank you, Chair. Honorable members, the President of the Republic, in his capacity as the leader of the African National Congress, he visited the area of KwaZulu-Natal called Pietermaritzburg, where a member of his political party, Mr. Musawenkosi Nhlanhla Mkhwanazi, was killed. And after the visit, the president then addressed the gathering that was outside the house. And this visit was on the 18th of May, 2018. In his address to the public, the president made announcements that he shall establish, or he has given a task to the group of ministers, and he's given them assignment that they must come with a solution, strategies to intervene with regard to mitigating these incidents of the murders of politicians in the province of KwaZulu-Natal. So this group of ministers were given timeline of a week to come up with a plan of how this, or a strategy of how this matter was going to be addressed. Honorable Chair and members, I'm not quoting the President directly on his own words, but I invite the members to go on YouTube if you so wish. Google that visit. You'll hear in your own words what the President said. And this was a Friday, the 18th. On a Monday, the ministers that were given an assignment by the President, they convened in the provincial office of KwaZulu-Natal at Bramfisher Street in Durban. And that is where the discussion with regard to the plan of how should we resolve these issues, mitigate these incidents of attacks on politicians or political leaders within the province of KwaZulu-Natal was discussed. And then subsequent to that, the President of the Republic appeared before the Parliament. I think that was on the 24th of May, where the President made a pronouncement with regard to the establishment of the interministerial committee that is tasked with the responsibility to develop measures that are going to mitigate these incidents of violence that is directed at politicians in the province of KwaZulu-Natal. So basically, that is a background of how the whole political killings task team came about, that it was a direction that was given by the head of state to the group of ministers, which are referred to as the interministerial committee. And subsequent to that, the work needed to be done, and then the officials ourselves then had to get busy with it.
Thank you. Who was the Minister of Police at the time?
At the time, Minister General Cele was the Minister of Police.
So subsequent to the establishment of that interministerial committee, what role has that committee, or did that committee play subsequent to that, from 2018 through to, say, the end of 2023? I understand the last interministerial committee was held, I think, in September or November of 2023.
On frequent basis, Honorable Chair and members, the IMC will, at the beginning, when they wanted to get the status of what the police are doing in terms of dealing with this crime, a presentation was made to them by the management of the South African Police Service in KwaZulu-Natal at the time. That was done by the Deputy Provincial Commissioner at the time, because the Provincial Commissioner who was there was on suspension. And the ministers were not quite pleased with the level of performance of the SAPS at the time. When looking at the number of cases that were brought to court, number of arrests that were effected, and as a result, a directive was that the police management must come up with a proper plan that is going to have timelines with a coordinated effort to investigate these incidents. And subsequent to that, the plan was drawn up, which was then approved by the National Commissioner, and the presentation thereafter was given to this interministerial committee, and they endorsed that. They were quite happy with it. And thereafter, they will frequently visit to come and evaluate the work that the team is doing and listen to the challenges that you are experiencing and trying and assist us to intervene in those challenges. And that's how it's been working. And every time when we meet and we give them a status of the work we're doing, they will go and then brief South Africans through the media. They will have a press conference where they give a status update with regard to the interventions they are making. So I like to believe then that perhaps they will have elevated the same report back to the president as a person who had assigned them. So that's how it's been working up until towards the end of 2023, whereafter this interministerial committee has not said. I like to believe it was towards the end of the year when they last met. And then the following year, 2024, the country was gearing itself to go to the national elections. And after the national elections, the new ministers that took roles of that were appointed into positions of those that were responsible for this committee had never convened. So we do not know what is the reason.
So if we can just pause at the end of 2023, so up until that point, from its formation in 2018, the minister was Minister Bheki Cele, former Minister Bheki Cele.
Yeah, that's correct.
Yeah. Who made the presentation and who devised the plan which was then presented to the interministerial committee?
The plan will have been worked out by the team that was given the responsibility in KZN, which will include the officials that were there at the time, and myself as a person who was the acting provincial commissioner, and some of the deputy national commissioners that were there at the time that had to also contribute in terms of development of that plan. A plan which eventually then had to be given to the National Commissioner for approval. So the National Commissioner was the one who approved the plan that was developed by a different group of senior police officers that were involved.
In terms of this plan, was the PKTT then accountable to the interministerial committee?
The task team was a team that was employed to work and execute police work that had to be approved by the National Commissioner. So it was accountable to the National Commissioner, not to the IMC. But the work of the team, the successes and that the team was producing, that the National Commissioner then had to account to the IMC on the work that was done. I must just indicate, Honorable Chair and members, that at the beginning, it was only the ACPS that was mainly focused on it. But as the time went on, we realized that we're having challenges as we're presenting to the IMC some challenges, which then made the IMCs to give specific instructions to the head of other departments that are within the security cluster to also organize themselves similar to how the SAPS are organizing themselves and dedicate personnel that are going to be focused on these cases. And as a result, a revised operational working was then developed, which then was approved and adopted, and which then was implemented going forward. So the coordination, the presentation that needed to be done to the IMC will then be presented by the group of the head of departments. The National Commission of the South African Police Service, the Chief of the Army, the head of State Security, the head of the Prosecution Authority in the country, the head of Correctional Services, were amongst the heads of departments that were part of this work that was done, which they would present to the IMC in order to account.
Is that where this word multidisciplinary task team comes from?
That's correct.
It was informed by a number of other actors and state actors, for example, prosecution-led, guiding and directing the work of the PKTT to give it a more dedicated focus. Is that where that comes from?
That's correct.
Yeah. So just to perhaps preempt a discussion we might have later, or some of the honourable members may ask of you, when we deal with this directive of 31 December 2024, it will be argued that not by me, I'm not here to present any arguments, but by some implicated, that this was a political initiative. It was a task team established and appointed to perform a particular task from time to time, and the decision to disband or to disestablish it was a political decision, and it was entirely lawful for such a decision to be taken. What would be your response to such a proposition or argument?
Yeah, I'll say they are wrong, Chair. I'll say they are wrong because a minister of police is not a member of political party. The minister of police is executive member that is appointed in terms of the law of the Republic. He's a cabinet member responsible for policing. I don't think the legislature cared as to which political party the member belongs to. So to put a statement and say it was a political decision, what if the minister is not a politician? So I don't think that argument will stand.
Okay. So we'll perhaps explore that a bit later when we come to the Minister's Directive, Minister Mkhwanazi's Directive of 31 December. But just to establish the PKTT as an entity. So this was, is it right, this was not a permanent structure. It was a task team that was established over initially a 6 months period, later on over a year, but it was resourced and financed from the budget of the police, in respect of which all of you as senior officers informed that budget, and it was approved by the National Commissioner. Would that be a correct or a fair summary? Or do you want to elaborate?
Honorable Chair and members, the team, as it was working, the SAPS dedicated specific funds from the national level to be utilized by this team. And it was not the budget that was allocated to the cost center of KwaZulu-Natal as a province. Therefore, it was an extra allocation. However, the other departments, be the NPA, who had dedicated prosecutors working with the team, correctional services, and many SSA, and many other departments that were part of the operation. I believe they were using their own line function operational budget to execute the task. But I'm speaking under correction. I'm not sure if they had any specific budget allocation for the project. But in the ACPS, which I can speak on, there was a dedicated budget allocation. It might not have been according to what we had asked for, because the CFO needed to make money available. Sometimes we'll ask for 10 million and she'll give you 5. But there was a specific budget for the ACPS. I'm indicating these, Honorable Chair members, that so that it is understood that ACPS was using the budget, but not only ACPS was working in this team. There's NPA, there's correctional services, and there's other entities that were using budget. So I can't speak on their budget. So I'm only talking about the ACPS budget.
So would it be fair to say that this, in summary, about the PKTT, it was a political initiative that was then operationalized by or through the Office of the National Commissioner, fully funded, fully resourced by the police, and subsequently also informed by other state actors, like, for example, the NPA and others, to form this multidisciplinary team.
Honorable Chair members, I'll beg to differ again. It was not a political decision that was implemented by the National Commissioner, but it was an executive authority decision that was executed by the heads of departments within the security cluster, which include the National Commissioner.
Okay. So, what role, or what was your role within the PKTT? Did you lead the team? Were you the project leader? Or was Brigadier Khumalo was appointed the project leader? Who appointed him as project leader?
Honorable Chair and members, before the meeting of the 21st of May took place, the National Commissioner, as I said earlier when I started, that in KwaZulu-Natal, the Provincial Commissioner was on suspension. The National Commissioner had assigned me to go and act as a Provincial Commissioner in KwaZulu-Natal to oversee the province and manage the province. So in my taking up that position, I had requested the National Commissioner to allow me to take Brigadier Khumalo with me to go down to KZN and assist me with the managing of the province, which the National Commissioner approved. So on our arrival in KZN, we were there for managing the province. So when this tasking came, it was a task that was given to the province to make sure that the attacks to the political leaders in our province is somehow minimized, and we're able to deal with perpetrators and put a stop to the incidents that were happening. So by default, the Provincial Commissioner, which was myself, was part of this. That means I had to be responsible for what was happening at the time. As I said, when the plan was developed, it did not only include the Provincial Commissioner alone. So the plan was put together. As a person in charge of the province, initially, I took responsibility for it. And as I moved out of the province, it needed to be overseen throughout the process, including myself while I was out of the province, but overseen by many senior officers that were given a responsibility to oversee the working of the team. So I was a Provincial Commissioner in the province. the team was given an assignment, a responsibility to a major general who was at the national level, who was at detective services. He was appointed as a project leader, and then he was assisted by 2 brigadiers. So he went on retirement, and another brigadier was then given that responsibility to take over from him. But as I say, they are accounting to the provincial commissioners, myself, and then the accounting was going all the way up to the national commissioners level.
So the budget for the task team, was that allocated at national level, but the task team itself was in operation at a provincial level?
That is correct. The task team was working at the provincial level while the budget was a national budget.
And just describe the command structure and the composition of the team. Was it the officers in the team, were they only based in KZN, or were they drawn from other parts of the country, other divisions, other units?
Honorable Chair and members, the team was made out of different expertise from the different parts of our organization, which were drawn from different parts of our country as the organization is spread across, where we need to get the expertise to come and assist. Those expertise were then invited from different stations, different units in the rest of the Republic to come and assist the team.
Just to reference him, because he will also come and give evidence before the committee, did General Masemola at any, he was obviously aware of the existence of the team, and when he became the National Commissioner, he would have been instrumental in approving the budget for the team. Is that right?
The National Commissioner, when they started, the current National Commissioner was not the head of the organization, so he did not approve the budget.
But
he was one of the people that were signatories requesting the budgetary approval. But upon assuming the office of the National Commissioner in 2022, he then became responsible person to allocate funds to the project.
This team, what was its membership rotated from time to time? And if so, what was the reason for rotating the membership of the team?
Yes, Honorable Chair and members, when the team started, perhaps maybe what I must give as a background, which I didn't talk about, is that although the existence of this team started after the President made a visit in Pietermaritzburg in May 2018, but the incidence of this violence nature in KZN, it's something that was already in existence for a couple of years prior. And it was a concern already, not only within the provincial leadership or executive in the province, but it was a concern at the national level as well, because it was something that, a crime that was directed towards the leaders of our society, which was a concern. And at that time, the Minister of Police sought to direct that the police must do something extraordinary to handle this. At that time, the Minister of Police was Minister Fikile Mbalula. And they had directed that some intervention must be done to try and correct or arrest this situation that seems to be getting out of control. General Masemola, who's now the National Commissioner, was still a deputy at the time. So there was a tasking given to the province of KwaZulu-Natal to say, KZN have special focus on cases that involve politicians, so that you can try and make sure that you improve in terms of arrest and taking cases to court. When this incident continued up until May 2018, when the Interministerial Committee came to KZN, then the committee was given a presentation on what the police were doing in terms of those cases. So the status quo that was there at the province. So they were given those presentations And upon assessing that, it became clear that the performance of the SAPS at the time was not very encouraging. It was very poor. And it was for that reason then that the IMC emphasized the point that something else must be done to better coordinate and see the speed of finalization of cases. And when the team started working, Honorable Chair and members, as we reconfigured it into what we refer to as PKTT now, because it was a combination of different disciplines, it was not only detectives alone. Before, it was only detectives alone that were working in dealing with those cases. Now, when this team was formed, it had forensic experts in it, it had analysts in it, it had intelligence members that were working in the team, dedicated by different departments within the SAPS or divisions within the SAPS. So some of the things that were then observed, Honorable Chair and members, was that there is a lot of corruption within the South African Police Service, detective members that are carrying dockets. And the team then had to deal with trying to eliminate the rogue members within these cases, because some of members are carrying dockets, and not because of the poor investigation from their side, but it's a deliberate omission of some of the information that must be in the case docket so that the case doesn't go to court. And that led into an arrest of quite a number of police officers that were working in that team. Quite a number of them to date are still in prison. As we engage, giving this evidence with this ad hoc committee, you'll be privy that some of the members are in cahoot, those members arrested that are in prison. Some of them are now in cahoot with some of the honorable members in this parliament, feeding them with information. So when we discover that these members are this corrupt and they get arrested, and then we realize that we cannot then risk to have more members getting corrupted or be recruited and be paid money. So therefore it is important, we must try by all means to rotate them. So the rotation of members was then influenced by that. Although unfortunately it was not all the members that needed to be rotated. We'll rotate some of them and some of them will stay behind. And a typical example, it's not easy to rotate a detective when he's carrying a docket because he's an investigating officer. But what we made sure is that the detective doesn't work alone. He works with a group of other members around him or her so that we prevent any involvement in corruption, as it were. So, yeah, the rotation then took place, and the reason for that rotation was exactly that, what I've explained.
The rotation, did it take place every 6 months or every year? Over what period?
Honorable Chair and members, again, as part of, we put up a plan together and we want to roll it out and have a perfect investigation. But as we realize that we have these bad apples within the SAPS that we try to deal with, we also realize that we have a bad apple within the prosecution that we have to deal with. And we also have bad apples within probably in courts that we have to deal with. We see a case that a team initially, it was said to be going to be working for 6 months. And when the team makes arrest and the cases are brought before court, and the court will schedule a case on the month number 7, when the team's supposed to have stopped. And we then have to request the extension of the team so that the members stay on to continue these cases in court. And when the matter goes to court, when the extension is granted, it's granted for another 6 months. And when this case arrives in court on the month number 7, it gets postponed again to the month number 15, just outside the deployment date. So we then realize that this postponement with timelines, it perhaps that's a reason why they are postponing these cases to days after where the member is supposed to withdraw. We then requested to the National Commission, let's change our strategy. Let's not put timelines. Let's just keep the team indefinitely for the whole financial year. And from there, we started seeing cases being enrolled in court because then there was no end date for the team. And then the investigation started happening and cases were then being placed on the court roll.
Yeah, that's why I asked the question about the rotation, because it clearly could or did affect the prosecution of a particular case. If a member was rotated and the prosecution was still pending, it affected the issue of until when do you postpone a matter, and when the matter comes back to court, is the officer concerned now still part of the unit, or has the person been replaced, rotated? I asked the question for that reason. Yeah. So let's just talk about your relationship with Brigadier Khumalo. You know each other well? You would describe yourself as good colleagues?
Honorable Chair, members, there are too many Brigadier Khumalos in the South African Police Service. Can they maybe say be specific?
The project leader of the team, PKTT.
Yeah, he's a colleague. The head of crime intelligence you're talking about.
Yes.
Yes, he's a colleague. I know him very well.
So, would you still describe him as he's the project leader of the PKTT?
That's correct.
Notwithstanding the fact that he's also been, or had been appointed as the head of crime intelligence.
That is correct.
Given the very important role that crime intelligence plays throughout the service and for the country, was it feasible for him to continue as the leader of the PKTT, given this very wide and important role he has to play as the head of crime intelligence?
Yeah, Honorable Chair and members, we are giving assignment in the South African Police Service because it's something we do all the time in our careers, that we are having a responsibility in terms of your line function. That's what you're employed for, and that's where you are you're drawing a salary from. But then you give in other ad hoc projects on the side. Typical example, if I may use a current project that everyone should know about, that the head of the investigation in the province of Western Cape, which is a province that is too much in the media of late with regard to incidents of violence that are happening. But the head of investigation in this province has been deployed to France to go and assist, to lead a team in France to go and assist with regard to the investigation of the death of the ambassador. It's a temporary thing. He's going to come back and continue with this province. So it's a common trend across the SAPS, we do that.
Now, I was just asking and wondering that Brigadier Khumalo appointed head of intelligence, project leader of the team, and you're the provincial commissioner of KZN. Both of you played key important roles in leading that team. Your capacity to continue to lead the team and to play the role that you had since 2018, was it still possible to do that given your other responsibilities?
That is correct, Honorable Chair. I was in KZN in 2018 and 2019. July, I went back to Pretoria, as I said earlier. I was a divisional commissioner of operational response services, but I still had the responsibility also over the political task team during that period while I was in Pretoria.
So the record, and we're going to come to that in a moment, of the PKTT in terms of combating, fighting political killings and prosecutions, would that have been shared with this interministerial committee when it met, I believe, twice a year? Is that right? Twice a year, the interministerial committee?
Yeah, well, the frequency of the meeting, I don't have it in front of me, but I know on annual basis the committee will meet, the interministerial committee will meet and take reports.
Yeah. And so that report would be given by the senior management of SAPS?
That's correct.
Which includes the national commissioner and his deputies and other heads of departments.
That's correct.
Were you involved in such a briefing?
Yes, I was. In many of them, I was part of those briefings.
In your capacity as the provincial commissioner, or in your capacity as the leader of the PKTT? And the role that you played there, you clearly played an instrumental role in its establishment and the subsequent work that it did. But we know also from your employment record that you were at head office and then assigned sometimes to KZN and also to the Western Cape. And so there was quite a bit of movement, but you continue to play this role within the PKTT.
Yeah, no, that's correct. I will be providing the presentation to the Interministerial Committee as the person responsible for the province in KwaZulu-Natal and responsible for the project at the time. But when I moved to Pretoria, I was not as much involved in terms of briefings. So the briefing were handled by General Khumalo in the main, because I will also be traveling from Pretoria coming down to KZN, and he would give the presentation as a person that was always in the province.
Yeah. So certainly at a political level, when you reported to the Interministerial Committee, they would have been aware of the work that the PKTT was doing. You would report to them whether people were being arrested, whether they were being prosecuted, and whether these prosecutions were successful or not successful. In other words, their record would have been shared with this committee at least on an annual basis.
Honorable Chair, members will always give presentation to the Interministerial Committee as on a strategic level without going deeper into the details of the investigation in terms of saying who is a suspect and who are the people intending to questions and so forth. It would be safe to just say to them, in this case, we've identified the suspects involved and we've effected an arrest on them. Is a matter in court or not in court? What is the obstacle and those things? So it was more on a strategic level as an oversight body, not bothering them with regard to the details, because that the security of the investigation needed to be protected all the time. So we did not divulge that information when we were giving them presentation.
Yeah. So you deal at paragraphs 12 to 13, what you under the subheading successes of the PKTT. Would you describe the PKTT as a success?
I will say the work that the team did was a good work, and the results that the team had achieved over time were good results that we could be proud of.
And would you say that its continued existence is justified?
Yes, that is correct. It still exists to date. And we're quite happy with the fact that they still exist, considering the fact that we are approaching elections. We wouldn't want that which used to happen in the past to start again.
Now, you made a presentation, a presentation was made, I think, by Brigadier Khumalo on the 5th of March before the Police Portfolio Committee. You attended, or rather your name was on the list of attendees at that meeting, but were you privy to that presentation that Lieutenant General Khumalo did at that meeting? And you would have also seen it at Annexure NSM 4 to your statement.
Honorable Chair, members, it is true that the SAPS appeared before the Portfolio Committee on Police on the 5th of March 2025. The presentation that was made by General Khumalo as a Divisional Commissioner of Crime Intelligence and also the leader of the Political Killings Task Team before the committee on that day was not given to me. I did not have a copy of that presentation. But I was part of that sitting of the committee, so I am aware of the presentation, of which a presentation is subsequently received after the sitting of that portfolio committee.
And you weren't present yourself, but a further similar presentation was also made on the 6th when the minister got a presentation from senior management in the police.
I do not know about the meeting of the 6th, Honorable Chair.
Just before we move on about the success of the team, did the team also operate outside of KZN?
That is correct.
Just give us some examples or tell us in which areas, other areas outside of KZN did they operate in?
The Honorable Chair, members, the National Commissioner gave the assignment to the team to go and assist with the investigation of cases at the University of Fort Hare in the Eastern Cape. And after that, there was also a request for the team to go and assist with the investigation of organized crime in Gauteng province. And also, they also assisted, they were invited to participate in an investigation of one case specific of Umtata in the Eastern Cape that they were assigned to assist on. So I know of those three interventions that the team made outside KZN.
And those, they were assigned to do that by the National Commissioner?
That's correct.
Okay. Just for the record, can I ask you to refer to Annexure NSM 2, which is on pages 23. That is a transcript of your presentation 23 to 31. It's in volume, Honourable Chair and Honourable Members, volume 2, which is the annexes to your statement. Volume 2. Volume 2. Page 23. And I just want to ask you to turn to page 24, the last few paragraphs, 4 or 5 paragraphs. So this is what was. Perhaps you could read it into the record from that paragraph that begins with, as a result of the excellent performance, the political killing task team has been assigned to another presidential intervention project.
Okay, I quote on this annex, as a result of the excellent performance, the political killings task team has been assigned in another presidential intervention project. I can name a few: the killing of the traditional leaders in the province of KwaZulu-Natal, as well as the murders that happened in the University of Fort Hare in the Eastern Cape. Since the establishment of this political killings task team in July 2018, the team has been investigating a total of 612 case dockets. These case dockets include murders, attempted murders, intimidation, conspiracy to commit murders, and other cases. A total of 436 suspects were arrested and charged. 156 firearms were recovered, of which 55 of them were linked directly with a ballistic bullet through a forensic testing to the political related cases. An additional 35 suspects who are members of the South African Police Service were arrested. The notable one is the one who is now in prison, who has been working with a parliamentarian who was involved in the murder about of one Cindy Somakado. We are going to talk about that later. A total of 128 accused were found guilty on 106 cases. 29 accused were sentenced to life in prison. 40 accused were sentenced between 10 to 35 years. 25 accused were sentenced between 1 to 9 years. 23 accused were sentenced between 3 to 12 months.
And then while you have that annexure there on page 25, and this is, I reference this because this is where it appears the team operates outside of the KZN. On page 25 of that annexure, almost in the middle of the page, that sentence begins with, in the year 2024, a request was received from Gauteng, an organized crime investigating unit. Do you want to read that or discuss that with us?
Yeah, well, I can indicate that in 2024, the Gauteng organized crime unit were investigating a case. That case then resulted into the threat that were directed towards the investigation team. And that threat was also requested, the threat assessment and the support to the investigation team was also requested by the prosecutor that was working on the case. And subsequent to that, crime intelligence were invited to conduct a threat assessment in Gauteng. And when the threat assessment was confirmed against those detectives that were working on that case, then there were recommendations that the South African Police Service tactical units of Gauteng must provide protection to the members that were working on that case. And then crime intelligence decided to deploy counterintelligence teams to investigate further on these threats. And when they conducted that further investigation on the threat, they discovered that the threat was actually coming from some criminal syndicates that are running, that are within that province of Gauteng. As a result of that, then crime intelligence decided to register a case to investigate as part of counterintelligence investigation. And from there, because of this threat that was identified towards the investigators, and also further assessment of the threat, there was also an identification of an infiltration of some of the members of the team that were assigned to protect these detectives. They were infiltrated as well. So when that came to the fore, identified by counterintelligence, then the divisional commissioner felt that maybe he should invite the assistance of the task team in KZN to help with that part of the investigation. That is when that engagement was made and the approval was then granted that at least 10 members from this task team must go and assist in Gauteng with that investigation.
And who would the divisional commissioner have been to make that request to assist?
It was the same Gerald Kumalo as a divisional commissioner of crime intelligence and also a project lead of the task team, but knowing that he cannot just take members from the task team and send them where he needed to, so he had to ask for the members to come and assist on the investigation within crime intelligence.
Did that not create a conflict between his position as the head of crime intelligence and also the project leader of the PKTT?
No, it did not.
Why do you say that?
He's a police officer. He works within the rules of the SAPS. That's why I'm saying that it did not, because he did not just take members from the political task team and deploy them somewhere else. He understood that these members from the political task team, they are assigned to work specific project. So if you want to make use of them, he must ask for permission for that to happen. Hence, he approached me, and hence the request to the National Commissioner before those members were released. So that's why I'm saying that there was no conflict between the two, because he asked for it.
So in what capacity did he approach you? You at the time, the Provincial Commissioner of KZN.
He approached me in his capacity as a Divisional Commissioner of Crime Intelligence, because the case he was investigating was registered within Crime Intelligence. So it was a Crime Intelligence project.
Well, just looking at the statement, it wasn't it a Gauteng case? Didn't this create any jurisdictional issues?
No, the South African Police Service operates in the corners of the Republic of South Africa, so there's no jurisdiction.
But at the time when the matter was being created, this is being headed by senior police within Gauteng, and especially in the organized crime unit. Who would have been the head of the Gauteng organized crime unit?
Okay, maybe let me clarify that part. This, when it initially started, it was a case of organized crime Gauteng, which means it's a unit that falls under the Provincial Commission Gauteng. It's a one where there were threats on. The threats that even the prosecutor that was working on the case wrote a letter to the police management to make sure that the members are provided with security support. The Gauteng management requested Crime Intelligence to assist with the threat assessment. So Crime Intelligence provided, they helped them with the threat assessment, and the threat was confirmed. So therefore, Gauteng province had to take responsibility to protect these members, not Crime Intelligence. But because of what Crime Intelligence picked up when they're conducting the threat assessment, that seems to suggest that there looks to be some organized criminal activities that are behind this threat. Then Crime Intelligence registered a counterintelligence investigation. So it was no longer Gauteng or KwaZulu-Natal or Limpopo. It was a counterintelligence within Crime Intelligence that was registered in the office, at the Crime Intelligence office, not under the Provincial Commissioner, but under the Divisional Commissioner of Crime Intelligence. So this request for the TN to come over there, it was a case that was under counterintelligence, not under the province of Gauteng. So therefore, there's no jurisdiction. The accounting executive person that accounts on that investigation is General Khumalo himself.
And to what extent would this intervention to request some of the task team members to assist in Gauteng, to what extent, or let me ask the question, did this not also engage Lieutenant General Sabia, who's the head of the detectives, and all the detectives throughout the country, and in particular in Gauteng, are accountable to him?
Maybe, Honorable Chair members, let me correct that last part.
Yeah, please do.
The General Sabia is not in charge of detectives in the country. Detectives, they fall under the provincial commissioners. So provincial commissioners are in charge of detectives. But there's a small amount of them that falls under the division, which is a divisional commissioner in charge of detectives, not the deputy national commissioner. But that is just correction that I wanted to make. I don't want to get deeper, Honorable Chair and members, on the how part in terms of what General Khumalo did as he was starting that investigation on the counterintelligence. Who did he engage with? General Sabia is his commander. Did he engage him or he did not engage him? I don't know, because I was not part of it. I'm just speaking on the third party as a person who was informed about what came about. But in terms of more detailed questioning with regard to the team, how it started and all that, I'll invite you to engage that with General Khumalo. But having said that, Honorable Chair members, I must warn you, I said this is a counterintelligence investigation. So what I know for a fact is that perhaps a Joint Standing Committee of Intelligence might be a better place to get to know the details in and out of how that investigation goes about. But having said that, I'm speaking under correction. Invite Gerald Khumalo to talk to it.
Okay, Senior Counsel. Thank you so much.
Honorable Chair.
Yeah, we are an hour since you started, and I see members have been taking notes every time you ask a question, just to check with the members if there will be any clarity-seeking question based on the questions that you have asked here. Can I rotate?
Chair, I hate to come through a point of order. Can I?
Yeah.
I think we agreed that today is the evidence leader and the general. And that if there is anything that requires agent intervention, it will be brought to attention.
Yeah.
So if no one brings anything to attention, please don't disrupt this. Because no one did anything. We were fine. We agreed evidence leader today with the general, and then tomorrow we will come with our questions. Unless the general is not audible or the question from the evidence leader is not clear, then that will be brought to attention. But for now, I think we're fine. We agreed that.
There was a member who raised a hand. That is why I'm checking with all of you so that it must not appear like I'm advantaging one member. So every time there is a member who raises a hand, it becomes an opportunity to all of you to check if you want to clarify anything. Chief Whip.
No, thanks, Chair. No, I think firstly we have clarified the issue that I suppose Honorable Malema was had forgotten. There was a principal position that even today there may be instances where some among us require clarification on certain matters. But I think what was not established, I saw on the group when you were saying after an hour at 4:20, you will check whether we've got questions. I think what we did not establish is the manner in which that is going to be handled. What I suggest, Chair, in agreeing with you, is that in instances where any of us has got a question of clarity to make, let's allow that member through you, by show of hand, allow them to raise a question. And I suggest that so that we don't delay and disrupt the proceeding, you don't make it an automatic opportunity for all of us, because that on its own might delay the proceedings. But if somebody raises hands or her hand, you are perfectly able to recognize them and let them speak for that few seconds and get clarity and we proceed. Thank you.
Can I check, honorable members, during this window there is no hand? Okay. Thank you very much, Senior Counsel. We can proceed.
General, just without wanting to get into any detail, so this counterintelligence that you mentioned to us, were you privy to that from Brigadier Khumalo? Or was that also off limits to you?
Honorable Chair members, in this instance, we're going to refer to him as General Khumalo. He was a brigadier in 2018.
Okay.
Yeah, he's now a general. General Khumalo was slowly briefing me about when he started, why he wanted these 10 members, but without giving the details. So I think as time went by, I started getting to know the details of what is happening with that investigation. Initially, I was not much informed about what was it about, but I became aware by default because of the letter of 31st of December that was directed towards affecting my environment. That's what led me to studying to get to know exactly what's happening in Gauteng.
Now, your press briefing on the 6th of July appears to indicate, and we'll deal with it in a bit more detail, that this is a national malaise within the South African Police Service, the infiltration of the service, the infiltration of the entire criminal justice system, all those allegations that you make. But you appear both at the press conference and in your statement, you appear only to reference or to refer to the examples of KZN and Gauteng. Is there a reason why you only do that, or is it also your evidence that this is widespread and is a national problem?
Honorable Chair, members, yes, I did address South Africans on the 6th of July 2025. I might have made a reference on incidents that seems to be affecting directly KZN and Gauteng, but I did during the press brief indicate that the criminality that exists does not only function within these two provinces, but it affects the rest of the country. Honorable Chair and members, what informed me, part of it, we are sitting in a province where one fellow police officer was traced by criminals and killed when he arrived home. May his soul rest in peace. And when we saw what was then happening at the time, we then realized that a part of the problems that the members in the Western Cape were fighting for are pretty much involved in Gauteng. They stretch from Western Cape to Gauteng. And we have many examples of them. The late general who was in this province dealing with gangsters had traced the involvement of illegal issuing of firearms by our very own Farm Control Office in Pretoria, illegal issuing of firearms to the criminals in Gauteng. And there's criminals in Gauteng that are involved in drugs, and the drugs that the Gauteng team is part of, and the drugs that do come from the borders of our country, which it's in many provinces. And so it's not necessarily a problem that was a KZN and Gauteng province. It's a problem that involved the rest of the country.
Now there's a board that is established, which is composed or comprised of all the senior officers, headed obviously by the National Commissioner, provincial commissioners, and also divisional heads. Is that right?
You talk about the Board of Commissioners?
Yes.
Yes, there is a...
And how often do you meet?
Ideally, it sits on quarterly basis, but sometimes the meetings get deferred in case of emergencies, there are ad hoc specific meetings that are called in between.
So are or have these national or these issues which you say also applies nationally, have they been raised there? Have they been discussed there? And if so, were any strategies devised to deal with them?
Which things, if I may ask, Honourable Chair, specific you're referring to?
Well, I started off by asking you whether the issue between KZN and Gauteng and this issue where the PKTT members were seconded to Gauteng to assist, to protect, and the cartel, the drug cartel in Gauteng, whether this is only limited to that province, or whether it's also a malaise that affects the rest of the country, and you seem to indicate that is the case, and you also reference the Western Cape and we know of the notorious gang culture here. So I'm asking whether these issues are discussed at that board level where all the senior police officers are there and you can raise these issues so that you can obviously address them, and if they are so serious that you find some way of dealing with them.
Yes, Honorable Chair and members, the Board of Commissioners has a specific agenda that it works on, and the agenda of the BOC will involve the discussions with regard to the crime in the country. We will talk about the matters that are coming from the operational section of the police, which is referred to as the National Crime Combating Forum. We will discuss matters that are coming from the administration side of the police. So majority of the issues, intelligence briefing is part of the agenda items. So matters that the Honorable the SC is asking in relation to the cases that the political or the organized counterintelligence that we're investigating in Gauteng are part of those discussions that are taking place within the BOC through the NOC and intelligence briefings, but not in details. That's on a high level. The detailed part in terms of project on on operations are discussed within the National Crime Combating Operations structure.
And would there, when was the last such meeting?
The Board of Commissioners meeting.
Yes.
Yeah. I will have to remember. I've been so busy since July to date. But it did happen, I think, at the beginning of this financial year. I'll remember the date. It could probably be around June or so. There was a meeting that took place. But I can give you the date if you really want to know the last meeting.
Well, not necessarily, but I just wanted to ask or establish or ascertain whether such a meeting was held where these issues could be raised before you went public on the 6th of July.
You're talking about the issues that are raised in public. Yeah. Definitely those issues were not for the BOC.
Why?
Maybe I should share the agenda item for the BOC, then it would be easier for you to understand what does a BOC discuss and what does a National Crime Combating Forum discuss and what other different forums we have in the police, what is it that they discuss? These which I spoke about on the 6th of July were matters of strictly within intelligence space, if I can use that word, but were matters that were affecting the work of the PKTT. A PKTT only working in KZN. And the only person that will know about the works of the PKTT other than General Khumalo will be the National Commissioner. And the rest of the other people, you bring a provincial commissioner of Northern Cape, of Western Cape, and you bring the PKTT into the agenda item of the meeting that these provincial commissioners are attending. It doesn't concern them much, the issues of PKTT. So those activities that we ended up talking about on the 6th of July are experiences and things that were picked up during the investigations that were conducted at the counterintelligence operation that was running in Gauteng. And subsequent to the letter of the disbandment of the team that was signed on the 31st of December.
Senior Counsel, I have a request from the members that you should speak closer to the microphone.
Oh, it was on. Can you hear me now? Sure. Sorry. Maybe I lost my voice this morning.
The members are the ones who must indicate to me if they hear you.
Thank you. So General, perhaps it's then appropriate to move to the ministerial directive of the 31st of December 2024. Now, just before we get there, just so that we can get the chronology out of the way, up until that last interministerial committee meeting in, what was it now, September, November of 2023, the minister then would have been Minister Bheki Cele. Is that right?
That's correct.
Yeah. Would you say that he was a supporter of the PKTT?
The Minister of Police, together with other ministers that were assigned by the President, they were quite satisfied with the work that the team was doing. I wouldn't say he was a supporter. This is no football claim. This is the police work.
Yeah. And then in 2024, we have the general elections, and subsequent to that, we have the formation of the GNU, and we have the appointment of a new minister, Minister Senzo Mkhwanazi. What was your response, if any, when you heard that he had been appointed as the Minister of Police?
I did not respond to anything. I took note.
Do you or did you know him at the time of his appointment?
Yeah, well, besides knowing the minister as the former premier of the province where I come from, but I had personally met him in his own house prior, I would say, few weeks before his appointment to the police. I was privileged to meet with him in his own house.
What was the occasion of that meeting?
It was a meeting arranged by the Chief of Staff, Mr. Nkabinde. He personally wanted to introduce me to the Minister of Water Affairs. So I drove with him into his house, and we met, we drank coffee, and then we got to know each other. That was that.
So, but this is, when you talk about the Chief of Staff, this is
Mr. Nkabinde.
Mr. Nkabinde, who subsequently was appointed Chief of Staff when
That's correct.
Mr. Mkhwanazi was appointed. So,
Yeah.
so at the time, Nkabinde wasn't yet the Chief of Staff.
Yeah, well, I was unemployed at the time.
Was he not employed? Was he unemployed?
Unemployed. Not employed, unemployed, say.
So, and you obviously knew him, Mr. Nkabinde.
Yes, I did.
How did you know him? What was your relationship with him?
I got to know Mr. Nkabinde because he was working at IPIT and he was close to the one investigator within IPIT, Mr. Nhlanhla, who was working with him at the time, the late Mr. Nhlanhla, who was a brother to a colleague of mine who was working in the police, was a brigadier in the police. So I then eventually got to know Nkabinde through him, and then we became close with Nkabinde as well.
And Nkabinde, did he do any service in the police?
Nkabinde is a former policeman. He left the South African Police Service as a junior member as an investigator and was recruited by IPIT, and he worked at IPIT for many years, and then he left IPIT and he was unemployed after that.
What was his rank in SAPS when he was at SAPS?
I'm not sure exactly, but he was holding a junior rank. I think he was an uncommissioned officer, perhaps between the rank of sergeant and a warrant officer, but I'm speaking under correction. I'm sure if he's invited, he'll be able to give his profile. But he was one of the junior members when he left the service.
And what was the reason that he left SAPS?
I think it was greener pastures to go to IPIT. It was a higher position that he applied for.
So he became an investigator at IPIT. Who headed IPIT at the time?
Mr. Robert McBride was the boss of IPIT at the time.
And what would have been the reason why Mr. Nkabinde left IPIT? Did he leave IPIT? Was he dismissed? What was his reason for leaving?
Honorable Chair and members, I wouldn't necessarily know the details. Perhaps he will elaborate on that. I can only speak about what he told me. Of course, it was not under oath. He was talking to me as a person that was close to. his words to me was that he couldn't stand the wrong that is happening at IPT. Between his boss, Mr. Robert McBride, together with a famous Paul O'Sullivan, and the current head of IDEC investigation, Advocate Sissoko. He was just not happy with how they were doing business at IPT at the time.
So he resigned, that seems, according to you, out of frustration.
What I know is that there were issues that he was resigning and they were charging him departmentally. So there was quite a fight between him and management of IPT at the time.
And in particular, did you mention a fight between him and McBride and Paul O'Sullivan?
Well, I know of Paul O'Sullivan because he was very vocal in the media against Nkabinde. So I don't know about Mr. McBride exactly what was the issue because, well, I never spoke to him. Like I'm saying, I'm taking from what Nkabinde was telling me. Whether is that the fact or not, I do not know. If he comes here and come and explain, and Mr. McBride come and explain, perhaps Mr. Sissoko, Advocate Sissoko comes and explain, they might shed light as to what was the reason and how did they part ways with Nkabinde. But what I know is that there was trouble there that involved him and eventually left him.
And after he left IPID, was he unemployed for a period or did you assist him in finding another job?
Yeah, well, he was unemployed at the time, so he was just engaging on his own. I couldn't get him a job. I'm a civil servant, so I couldn't afford to, I did not have contacts to help him get a job. But I know that he was unemployed. I just cannot remember the duration, but he was unemployed for some time up until he received that phone call from the minister to appoint him as the chief of staff, where he shared with me as well.
Now, before his appointment there, you were close friends, did you say?
Well, he was a person that I was acquainted to. I was talking to him more often. He will share a lot of things, especially with regard to the work he was doing at IPT. So I ended up knowing more about those things. But in terms of his private life, what he does, I know he goes to church. Which church he goes to, I don't know. So I'm not that close to him to get to know those other private part of him. But in terms of the professional side of things, I got to know him. I said I knew him because of his colleague, Mr. Nhlanhla, who was working with him. So the relationship between me and him was more of a colleague relationship we had.
Okay. And the meeting that he arranged for you to meet with then Minister of Water and Sanitation, Senzo Mkhwanazi, how did that come about? Did you know that Nkabinde has a relationship, or what was his relationship with Minister Mkhwanazi, then Minister of Water and Sanitation?
Honorable Chair and members, the Senior Counsel is asking me some of the things that he's asking are not necessarily in my statement, but I will talk to it because I took an oath, although they are not here, but they can be investigated and proven to be correct. Honorable Chair and members, what the SC is asking me about what Mr. Nkabinde told me about how he got to know the Minister of Police, Mr. Senzo Mkhwanazi. Of course, it's something I'm going to present here, which I still need to establish myself the facts of what he had told me, which I have not finalized it yet. I'm still part of establishing the facts. But the fact is, he and Mr. McBride had flown, they took a flight from Gauteng, and they landed in Durban, and they traveled from Durban to Mpange at the minister's residence. And they went to meet the minister to go and tell him about the criminal investigation that the two of them were busy with at IPT. And it will appear that at the time that the minister might have been implicated on that case. But the two of them had somehow have some working arrangement with the minister. That's what brought the three of them close to each other. That's how the relationship came about. Well, I didn't believe much of what he told me. He mentioned that, and of course I asked, I said, but what type of a case? What is this that you were busy with? And he said there was a death of someone in KZN, and the minister at the time was accused to have interfered with the destruction of an evidence, a crucial evidence that was there. And that led into, because there was a police officers, bodyguards that were involved, that were working with the minister at that time when he was a premier. That led into the involvement of IPID, because IPID will ordinarily investigate cases that involve police. So that's how IPID came involved in that case, because there was a complaint of the police involvement on the wrong. So in their investigation, it led into some degree an act that the premier at the time have done wrong. That what made them to be close to each other. But as to the reason why they never arrested the premier at the time, I don't have the details of it. As I say, it's part of the things that I'm still making inquiries on, because he had not given me the case number by the time when he was telling me that. He just mentioned that that's how they got to know each other. The relationship started from there. To my surprise is that there is a one former chief of staff of the police, of the Minister of Police at the time, who also confirmed the same thing to me recently, not a few weeks ago. He said that Mr. Nkabinde shared the same thing with him. So that made me realize it means the relationship between him and the minister was formed out of an investigation that Nkabinde was doing. That's how they got to know each other. Because at the time, Nkabinde was not a politician, although of late I see him wearing political party t-shirts, but he was not a politician at the time.
And was it at the time that Minister Mkhwanazi was the Minister of Water and Sanitation, or was it at the time that he was the Premier? We know he was the Premier of KZN.
Are you talking about when they got to know each other?
Yeah, this other incident. I think earlier you mentioned the word Premier.
No, I'm saying that the incident allegedly happened at the time when the minister was a premier. But I think the time when Mr. Nkabinde, together with Mr. Robert Mwaprad, according to Nkabinde's words, not mine, when they went to meet with the minister, he was no longer a premier at the time. So I do not know where he was a minister of water or was minister of public service, but he was no longer a premier when they met with him. So that's how the relationship started, the two of them. Otherwise, the minister did not know Nkabinde, and Nkabinde didn't know the minister, but their relationship started on the day.
So when this phone call happened between you and Nkabinde, was Nkabinde unemployed?
Which phone call, sir?
To set up this meeting with the minister who was then Minister of Water and Sanitation, where you had coffee with the minister. You were invited to his house.
Yeah, he was unemployed, yes. Nkabinde, when he took me to the minister. Yeah, Nkabinde was not working at all.
So was that call coming from him, or was that a request that you made of him to go and meet with the minister?
No, it's Nkabinde that wanted me, since I'm a provincial commissioner in the province and he knows the minister, so he wanted, after he told me how they got to know each other, they're very close, he wanted to demonstrate to me that they are indeed close. So I drove with him, and I didn't have a problem in getting to the minister. So that's how I got to meet the minister.
And what business did you have to discuss with the minister in your capacity as the provincial commissioner?
No, nothing. It was just get to know the minister. I'm here. I'm a provincial commissioner here. I know that you're close to Nkabinde. He told me that you are close to each other. That's why we're here today. So other than that, there was nothing else. We just sat there and we talked general, and from there we left.
What was your impression of the minister at the time?
Well, I was convinced that the two of them know each other very well, him and Nkabinde. And then, because Nkabinde told me that they are close, I had to get a confirmation on the day that indeed they are close. So that's why when the minister phoned him, allegedly, when he called him to ask him to be his chief of staff, Nkabinde phoned me and he asked me, what does chief of staff do? Because he had no clue what's the chief of staff.
When did Nkabinde tell you that he was the chief of staff or was going to be appointed chief of staff?
Yeah, he said the minister wants him to be a chief of staff. He wants to appoint him as a chief of staff, and he had no clue what is a chief of staff.
And was that before the minister was appointed Minister of?
Before he was sworn in.
Before he was sworn in.
That's correct.
So how long before the minister was sworn in as Minister of Police did Kabindi tell you that Minister Nkunu was going to be appointed?
Your Honor, I will not remember the date. I will not remember the date. But I think it was before the official announcement was made, because it was in the evening when he phoned me.
What was your reaction?
The first was the chief of staff does administration, and I believe you're a policeman. I don't know whether you're going to deal with administration things on one side. On the other side, whether you know how to give advices on strategic issues of departments. At the time, I knew the minister was working in water affairs. And I asked him, so if you're going to give advice on ministers on issues of water affairs, I don't know if what you know about that business and so forth. So then it came out later that actually he was not going to Home Affairs, was coming to the police.
So when the announcement was made that Senzo Mkhunu was going to be appointed Minister of Police, you were not surprised?
Yeah, well, I'm never surprised on any appointment. So it didn't bother me. It's the president that decides, so there's no expectation, so therefore there's no surprise.
Chairperson, Honourable Chairperson, may we have a short comfort break? And also the other issue I asked you offline, because we scheduled to have a meeting with General Sabia at 6. So one of us will have to attend to that meeting.
I want us to push until very late. No, it's just on a lighter note. I grant you the comfort break.
Thank you. Thank you.
And
it's just a short break.
No,
for Ms. Mokgweetsi to
I'm giving
gather
you
stuff and
the other details you will share with me. I'm giving you 15 minutes, honorable members.
Thank you, Honorable Chair. Thank you.
Thank you so much, General. We are going to have a comfort break for 15 minutes. Want to buy food? And it seems like we only buy option for now. Thank you. Yeah. Honorable members, thank you so much. The time that was allocated for the comfort break has been exhausted. So I'm going to hand over to the senior counsel to proceed.
Thank you, Honorable Chair and Honorable members, and thank you for the short adjournment. And General Mkhwanazi, thank you. You're still under oath?
Yes, sir.
Can we move to the directive of 31 December 2024? It is annexure NSM 5.
Just before I see hands of honorable members. I see Honorable Nombalo, Honorable Sangon. Let's hear what the issues are, Senior Counsel. Honorable Nombalo.
Yeah, thank you very much, Chair. Chair, I just want to be clear on the question and the answer that was given there too. In relation to the appointment of Mr. Nkabinde as the Chief of Staff, was he appointed in terms of the response that was given when the minister was a Minister of Water and Sanitation, or when he was a Minister of Police, or a Premier rather? And subsequently, there was a mention of an intention to appoint during a discussion that they had General Nhlanhla Mkhwanazi, Mr. Nkabinde, and Mr. Sonzo Mkhunu. At what stage did that discussion take place? And also, the response that was not clear to me is a response on the relationship between General Nhlanhla Mkhwanazi and Mr. Nkabinde. I think the question was asking a relationship in a context of their official duties and outside. Now, I'm not sure whether the question was only related to their official duties or outside, or they even have a relationship even outside their official duties. I just need clarity on that. Thank you very much.
You want to know the private part? Your question may be broken into 2 or 3. So please just satisfy yourself that all the 3 aspects of your question have been answered. Senior Counsel, remember you are the one who is leading evidence. So the honorable member has asked a question here, and can you please respectfully convey the question to the General?
Thank you, Honorable Chair. The question from the Honorable Member, General Mkhwanazi, did you hear that one?
Yes, I heard it.
Okay, then I won't repeat it because I didn't hear it. So
Honorable Chair, maybe to try and assist, I said earlier, myself and Mr. Nkabinde got to know each other on a professional level because he was working with someone that I knew. He was a colleague at IPT, a colleague of Mr. Nhlanhla, the late. Mr. Nhlanhla was a brother of a former police brigadier who was my friend. So I'm friends with Brigadier Nhlanhla. Brigadier Nhlanhla has got a brother who's Nhlanhla who works for IPT. And that Nhlanhla works with Nkabinde. That's how I got to know Nkabinde first. So the engagement in Nkabinde was always about work issues, mostly, nothing else. Until he's out of the job, then we'll start telling me about how is he trying to make the ends living and how he's trying to survive on things. So we ended up having those casual talks with him. That's why I said earlier, I don't necessarily know much about his private life, not much about his family. You know, I will know his house, I know his wife and his 2 boys, but the rest, I didn't necessarily know much about him because we're not friends to that extent. It's people that know each other. So the engagement between myself and Mr. Nkabinde and the minister only happened on a day when Mr. Nkabinde took me to Mpangeni. I drove with him to Mpangeni where we met the minister. And it was just to show that he knows the minister and there was nothing else more that was discussed. There was no promise of a job. There was nothing else. That's why I said earlier, I cannot remember at the time whether the minister was at public service or was at water or what, but I like to believe perhaps he was already at water. But because I didn't pay attention, I cannot tell you exactly definitely the day when we visited which department he was working for. But I knew that he was a minister at the time. So therefore there was no telephone calls between us in relation to his appointment. So his appointment as a chief of staff, I said at the time he was working for IPIT, he left IPIT, he was unemployed. Up until the Minister of Police, Mr. Senzo Mkhunu, was appointed as a Minister of Police. That is when he invited Nkabinde to come and join him to work with him as a chief of staff. That was the first time Nkabinde got to be employed, literally basically moving from a very junior rank that he was holding in the police to a chief director position that he ended up occupying, which he occupies now, a chief director in the office of the minister. So that's why I said earlier, when he received the phone call from the minister asking him to become a chief of staff, he had no clue what is a chief of staff. He phoned me to ask me, what do chief of staffs do? Because the only thing Nkabinde knew is a case docket, because he was just an investigator. That's all he knew. So when he's invited to become a chief of staff was a shocker to him, but I ended up telling him about the amount of money is going to be paid when he gets to that position. Obvious, I did not know about other qualifications I didn't need to have, but he was appointed. He became a chief of staff. He is a chief of staff now. I hope I've covered that.
Honorable Nombalo, are you fine? Okay. Honorable Sangun.
Thank you very much, Honorable Chairperson. I think I've got two questions for clarity, although one might be procedural. The first one, I know that the evidence leader did ask the general why he went to see the minister, and I think the general said they wanted to meet. That's where I need clarity, because I'm interested to know whether it's normal procedure that a provincial commissioner is just introduced to ministers, or was there any other reason? And then secondly, when the general then went to see the minister, was the general aware at the time that the minister was a person of interest? Because he would have had, he would be privy to this information that is coming out. Then, Chairperson, my last question is just about procedure. I'm looking for clarity on procedure. The general in his testimony did indicate that there are questions that are being raised that don't cover the statement. Now, we've said as this ad hoc committee that we're not going to try and push anything under the carpet, but I'm worried where we are going to constantly be encountering testimony that is not in the statement. Now, will we be getting a supplementary statement, for example, on those issues so that when we engage them, we would at least have them on the record? Thank you, Honorable Chairperson.
The Senior Counsel.
Chair, on the last aspect, Honourable Member, or do you first want to deal with the first part of your question?
Yeah, if you can please get closer to the microphone.
We did discuss, and I touched on it in our opening statement this morning, and we raised it with General Mkhwanazi in our consultation last when we recognized him ahead of yesterday, that I will from time to time ask him about matters or issues or questions that doesn't arise from his statement, for the reason that, this procedure or process is different from Nhlanhla. General Mkhwanazi is going to appear here today, and tomorrow honourable members will ask him questions, and then he will leave. Whereas at Nhlanhla, he has given evidence there extensively, he will have to go back to the commission to be cross-examined by those implicated by him in his evidence there. And also those implicated by him will get an opportunity to give their evidence to the commission and also be cross-examined, presumably by the evidence leaders. We here, before this committee, we don't have that luxury. I have put to General Mkhwanazi, and certainly he indicated to us that he doesn't have a problem with it, that we will also put to him, in fairness, the versions of other persons who are implicated by him in his evidence for him to respond, which is not necessarily in his statement, Honourable Chair.
I'm noting your hand, Honourable Malim. Let's allow the senior counsel first to facilitate for. Okay.
Chair, I really don't understand how you want us to proceed. Because it must be on the basis of technicalities, audibility, and things like that. If you're going to allow them to ask questions, we're going to ask questions. Don't do that. We agreed each member is going to get 30 minutes tomorrow. And if they ask questions now and tomorrow they ask questions on their 30 minutes, they've got 35 minutes. Are you going to afford me that? Please don't do that. The last question Honorable Sangoni raised, it's a proper question. It's a clarity, it's a procedural matter that, okay, now that this thing is not in the statement, what do we do with it? And the senior counsel clarified it. And that I accept that. What the general is being asked about is his relationship with Nkabinde, which is covered in the annexure from Madlanga. He spoke about Nkabinde in Madlanga. So remember, we've got this main statement, we've got annexures, and we can ask questions based on all of those annexures that are here, if you have gone through them. There's nothing irrelevant about that. But to ask the questions of why do you go to a minister? Is that a procedure to go to ministers? No, it's not clarity. It's not dealing with any technicality. It's a question that can be asked tomorrow in your 30 minutes. And if you're going to proceed like that, then they're going to get more time than all of us. And what do we do tomorrow? So it's unfair, Chair. Let the questions be on procedural issues, on technical issues. That's what we agreed on. Not anyone wanting to take advantage and we have more time at our expense. Thanks.
Okay. Can we agree that the questions will be answered tomorrow? Yes.
Chair will agree for the sake of peace, but you allowed questions from MK. But in order for us to proceed, we will stand down and agree. Thank you, Chair.
Yeah. Let's agree that those questions will be answered tomorrow. Can we? Okay. Honorable Novalo.
Chair, we just need clarity so that we will be clear as we move forward. Remember that asking question was on the basis of the proposal that was made by the Chief Whip of the ANC. That members can only be allowed to ask questions on issues arising from the questions asked by the evidence leader to the witness, not new questions, but on areas where we have not been clear in terms of the responses that have been given. And asking questions emanated from that. We're not asking new questions, but we wanted to be clear for our records so that when we make records, we make proper records from the correct understanding of what has been a response. So if there's a deviation from that, Chairperson, just say members will no longer be allowed to ask questions because it is a position of this meeting. And that position was motivated by the Chief Whip of the ANC.
Let me say this. I agree with the questions that you raised, Honorable Nomvalo. There is nothing wrong with that. I agree with the last part of the questions that Honorable Sankoni has raised. And her two questions that she raised first will be answered tomorrow. That's what we are saying. Is it very clear?
Can I come in, Chair? Now the question, Chair, is should we ask questions going forward emanating from a misunderstanding of what has been?
You wanted to clarify certain matters regarding the relationship that Mr. Ngabinde had with Minister Mkhwanazi. And the questions that you raised were not new questions. They were based on questions that were raised by the senior counsel. And that is why I say I agree with those questions. That is why I even came back to you to check if you were satisfied with the answers that were given. So it means if you may have questions later, you can still ask those clarity-seeking questions. Like Honorable Sangone had asked a question about procedural matters, which the senior counsel has clarified because it's a matter of procedure. But there are other two questions that she raised, which may be on the borderline. And that is why I agree with her when she says, for the sake of peace, let's continue. And I give a ruling because I don't want us to discuss the merits and the demerits of the questions. Where I stand, they are on the borderline. It may be very difficult if we may end up being polemical about them. So those questions are noted. They will be answered tomorrow. Is that fine, honorable members? Senior counsel?
Thank you.
May we please proceed?
Thank you, Honorable Chair, honorable members. General Mkhwanazi, I was moving to the Minister's Directive of 31 December 2024. It is NSM 5, which is on page 78 and 79. General Mkhwanazi, we can take it as read.
Yes, sir.
Yeah, and honourable chair and honourable members, this has been in the part of the bundle. So to save time, I'm not going to read it, and I'm not going to ask the witness. I just want to deal with your leave with the issues that arise from this letter. There are three: the freezing of posts in crime intelligence, the directive relating to the port of entry, and 3, the disbandment of PKTT. Any comment on why these 3 issues were packaged in this way?
Yeah, well, I'm not an author. The minister is the one who signed this. If I were to express my feeling about it, it was just strange that such strategic and very critical issues of the organization, never mind the fact that they're operational, but they're very critical, that a minister felt that it's important to send this communication in the form of a letter in this fashion, literally 2 days after the National Commissioner started his leave. And exactly almost 3 or 4 days after he parted ways with the National Commissioner, where he was with him in person in the funeral, and he never spoke about these things. So for such serious things to just be at that time of the year, be written like this, it makes one to ask questions as to why. I guess is that why question that led us here today?
Yes.
Yeah.
And I'm asking you why would three such key issues that seems to, your comment, that seems to fit into this narrative of organized crime, intelligence, borders, for example, drugs and illicit goods move across the borders, and of course the disbandment of the PKTT, which is going to be the focus of our attention. But just your comment, did this also raise suspicions on your part?
Yeah, when I saw it, immediately I said, but this is very strange. I just don't understand. I'm with the minister on a Saturday, together with the National Commissioner, and we part ways, and they all say happy New Year to all of them. And on the second, then the letter comes through, and it's a letter that talks about decisions that have got serious consequences in the organization. Stop filling vacancies now. When did it become so urgent that you couldn't talk to the accounting officer when you were with him a few days back? Now, of course, when we started asking questions, because these, at the time, one did not know why these specific three areas. But as the time progresses, then we got to understand why. And it is that understanding of the why that ended up leading us into try and intervene in the manner that we did.
Okay. Now, you deal with it, Honorable Chair and Honorable Members, you deal with this decision from pages 810 through to 17, paragraphs 14 to 30. I'm not going to ask you to read through it. I'm going to ask you some pointed questions that arise from it. Sorry. Is it correct that the minister had not received a single briefing from those in charge of the PKTT prior to the 31st of December, and in particular yourself and Lieutenant General Khumalo?
Yeah, well, I know now after engaging both General Khumalo and the National Commissioner that they didn't brief him, but from my side, I knew that I had not briefed him to date.
And between July 2024, when Minister Mkhwanazi was appointed by the President as Minister of Police, and 31 December 2024, there hadn't been any of this interministerial committee meetings that you had earlier described and referred to?
No, definitely, there were no such meetings.
You also saw the minister on the 28th of December 2024. What was that occasion? And at that occasion was Mr. Nkabinde, Chief of Staff Nkabinde, with him?
Honorable Chair and members, I cannot remember whether Mr. Nkabinde was there, but I do remember that the minister in our last meeting that we had with him in December, he was a functionary at the funeral of a police officer that died at Escaleni in KZN. And the Minister of Police was a functionary in that official funeral that was held there. So I was with him there. I do not know much about Nkabinde. I cannot remember.
So we're going to talk about when you learned about this directive, because as you can see, it's addressed to the National Commissioner, General Masamolo, and let me see if it's copied to anyone else. No, it's just addressed to him. So you weren't aware of this letter. We'll get to when you... but since you learned of this letter subsequent to the 31st of December, were you disappointed that he never raised this issue at all with you on the 28th of December when you saw him at the funeral?
Yeah, Honorable Chair and members, as the SC indicates that on my statement, I indicate I speak a lot, I write a lot about the events of the 2nd of January 2025 when I first became aware of this letter. My initial response from the time I saw the letter was just shocked and surprised that how can Misa write such a serious letter that is going to have so much implications in the organization. And more concern is that I had already met the minister, and I wouldn't want the executive authority to do things that is against the law. And so I have a responsibility to bring to his attention. But at the time, I felt it is important to use a shortcut because I got to meet the minister before he became the Minister of Police through Mr. Nkabinde. I know Mr. Nkabinde is the office of the minister. He had asked me what Chief of Staff does. So upon seeing this letter, he was the first person I called, because I believe that there cannot be any document going to the minister for signature without his knowledge. So I called him and said, Nkabinde, the minister signed a letter that says the following. Are you aware of this letter? And his response was, yes, I am aware of the letter. But according to him, the letter was going back and forth by whoever between the minister, whoever was drafting the letter and the minister. That made me believe that the minister is not the author. Someone else prepared this letter for the minister. And the minister signed it. Because Nkabinde's response to me was, after the letter was signed, after it going back and forth, then he was pressured to make sure this letter is delivered at the Office of the National Commission on the 31st. So, and hence the letter was delivered. So this was from his words that made me believe that there's someone somewhere who influences the minister to do this. I think they will give in the minister wrong advice. I wanted to correct that. That's why I felt it's important for me to plead with Mr. Nkabinde that, can you, Mr. Nkabinde, if you are coming down to KZN, you must arrange a meeting between myself, you, and the minister so we can sit down and talk about the implications of this. Because if the minister will have a letter like this that says we are disestablishing a team, there's consequences that's going to come as a result. And one of the consequences is that the minister might be seen to be defeating the ends of justice, because we're literally saying that the investigations that are currently underway must stop immediately. And that is going to have serious consequences of the minister. So I wouldn't want the minister to get to this, because I saw a risk that the minister is going to be held liable for this decision. So I wanted to address it with the minister and give him an advice, using Nkabinde as a person that I know is close to the minister, and I got to see the minister for the first time through him. But unfortunately, it did not happen.
So just to summarize, is it Nkabinde who told you that the minister was in fact not the author of this letter? Is it Nkabinde who told you that there was seemingly an exchange of drafts going back and forth before the letter was finalized? Is it that caused you to conclude that there was third-party involvement, whether it's one or more persons, we don't know, and also that made you conclude that this is not the minister's handwork, it's a third party involved?
Yeah, well, it was his words when he said this letter has been going back and forth, but he did not say who is the author. When he said it's been going back and forth, being corrected, and after that, he was pressured to make sure the letter is submitted. From there, I concluded that someone else was behind this letter. And Nkabinde had to facilitate it to send it to the minister for signature.
Sorry, Honorable Chair, may my colleague be excused? We've got a 6 o'clock scheduled with...
no, I have sanctioned that, Senior Counsel. Honorable members, Maria has to leave us because they have to conclude engagements with General Sibia. Thank you so much, Senior Counsel. You can
thank you, Chair and honorable members, for the indulgence. You must have been shocked at this revelation by your good friend, Mr. Nkabinde. Given the importance of these matters, all three matters, border control, crime intelligence is huge. We know it's been at the heart of a lot of issues in our country for a number of years. These are all important, critical issues. Now you hear there's been a back and forth. The minister may not have drafted the letter himself. You suspect third-party involvement.
It was indeed a concern, but I must say, Honorable Chair and members, on the day when I became aware of this, I couldn't blame Nkabinde on anything, because to me, he was honest to tell me that the letter was going back and forth, being corrected, and he was pressured to make sure that it's delivered at the Office of the National Commission. So I like to believe, that giving him a benefit of doubt, that on the day when this letter was drafted and subsequent to it being forwarded to the Office of the National Commissioner, he perhaps had no role to play with regard to the content of the letter, except to do the administration processes of it. The problem then came on the following day. When the following day, this letter, or the content of my engagement with him, appeared in the social media somewhere, that I threatened the Minister of Police with arrest and so forth, because I had said that if this is going to be implemented like this, the minister will be accused of crime, and that might end up bad towards the minister. So let's fix this. That was the exact same day when this letter was leaked. So unfortunately, the following day after talking to Mr. Nkabinde, the conversation between me and him was twisted somehow in the social media, but it landed at the social media. So then we had a conversation the following day where he said to me, he believes his phone was somehow been tapped by someone was listening to our conversation and so forth. He did not share the conversation with anyone. So that's when I started asking myself questions about Nkabinde himself. Because I'm engaging with him the day before, the following day, our conversation is on social media. It made me realize that perhaps he's the one that leaked it. Honorable Chair and members, I then am not going to talk much about what I became aware of most recently, that indeed Nkabinde was instructed to record me at the time. Instructed to record the conversation between me and him. So it means when I was talking to him, I was recording, and he would have shared that recording to someone. That's why that recording ended up in the social media the following day. But it was no mistake.
Can we just clarify this? You don't have copies of what was on social media?
No, I don't have it with me, but I can try and trace it. But there were a lot of, at the time, there were a lot of communication that was out there on the social media. But I can try and see if I can research. But I don't have anything with me here.
Yeah, because what I think we would also like to know is whether what appeared on social media, is it actually exactly the same as what was recorded in your conversation with him allegedly?
I can tell you, not all of it, but by and large, the conversation between me and him was there in the social media communication.
And forgive me if I'm offside, just tell me or ignore the question. But did I also understand that there's an allegation that you, when you spoke to Nkabinde, you had threatened the minister.
I was warning Kabin that if this letter, with its content the way it is not withdrawn, and the work of the police in terms of investigation come to a halt as is directed by this letter, this is going to have consequences towards the minister. Because the minister has got no jurisdiction in stopping a criminal investigation that is running. So this letter is literally saying that this team must stop with immediate effect. I'm not quoting verbatim, but it is basically, the task team be disestablished immediately. Those are the words. So if you are saying that, you are saying, if the case is in court, stop working. If the case is an investigation, stop working. Just stop everything at once. That's the consequences this letter has. So I was warning Gabin that you better make sure that you, and the minister sit and talk about this. Because I don't know what is the circumstances that led into Mr. signing it, but the implication of the letter will land the minister in trouble. So it was there that the following day, which appeared in social media as if I threatened the minister when I was communicating with Mr. Gabin.
So did you see either the whole or part of your discussion on social media yourself, or was this reported to you by someone that what is this that appeared on social media and you then saw it?
Yeah, well, I saw the communication. I cannot remember how it came to me, but I saw that communication of what was out there that was spread.
So did you speak to Nkabinde either on the 3rd after this appeared on social media or afterwards?
Yeah, we've been talking. Afterwards, we've been talking up until most recently. I think after my press briefing, then we pass each other now. We don't talk to each other.
But what has come from your discussions or talks with him? He appears certainly, with respect from what you're telling this honorable committee and us, that he seems to be a central figure in all of this.
In all of what?
Well, the letter, and you say that he knew there was a toing and froing of the letter. He also told you that he was pressured into getting the letter out on the 31st of December, is on New Year's Eve, which in itself sounds, I don't think one needs evidence on this. It sounds really odd that on New Year's Eve, such an important document is released. So I'm asking about his central role in this, his appointment as Chief of Staff, when according to you, he's not even qualified for this role, doesn't have the qualifications. I must confess, I don't know what the qualifications might be, but I suppose we can look that up on the public service regulations, what it entails. But it sounds to me that he wasn't quite qualified for the job. So that's why I'm asking you to comment on that proposition, that he seems to be quite a key figure in all of this. Honorable
Chair and honorable members, it sometimes can be dangerous to express your opinion about something that you don't have facts on. Since the S is asking me my impression I have is that Mr. Nkabinde was recruited or was appointed by the Minister Chief of Staff, and he had no clue about what Chief of Staff does. So he had to adjust in the office. He had to learn as he was going. That's why I know that the other former Chief of Staff at the office of the Minister can come here and testify that he also phoned him and seek advice as to what does Chief of Staff do. And he also had to coach him about what Chief of Staffs are doing. And so he had to adjust as you learn as he was going. And I think that's why even he started learning politics, because he was never a politician. So I see him today with T-shirts of political parties, which I don't think he even understands what it takes to be a politician. So he adjusted as he was going along to please his boss.
Learning on the job.
Yeah.
Okay. But what I'm curious about, and what I think many of us here would be curious about, is you continue to engage with Nkabinde. despite clear shortcomings that he has in that post, despite the critical role he plays in that post. A chief of staff presumably is very close to, that's why you appoint someone chief of staff.
Honorable Chair and all members, these things are happening. The letter comes out, I speak to chief of staff, and after that he said he tried to secure a meeting with the minister, is not able to, and next thing he says to me, no, he did not release the information that I was talking to him about. Perhaps someone tapped his phone or something like that. So I had no reason not to believe what he was telling me. So all the time, even when we meet in meetings, because the person I know, so we'll engage. As the time went by in this first 6 months of the year, I started getting more information about his role that he plays in some of the meetings, how vocal he becomes in some of the meetings, and which was strange to me but he's got no role there. How does he become this vocal? So slowly then I started monitoring his social media and then WhatsApp status. Then I started realizing he's no longer the man that I knew he was, because as I say, he's now a politician. He talks about politics and he displays T-shirts of political parties, rallies and all those things, which is now away from what the chief of staff is supposed to do. And that's when I started realizing that maybe is what I'm hearing about his involvement, about interfering with police work might be true as the time progresses. Until such time that eventually we started picking up other evidence. I think when I went public on the 6th of July, the lines were drawn between me and him. So we never really engaged after that.
I think you've answered the question that initially you were reluctant to answer. You don't want to express an opinion on Gabinde.
No, I said sometimes it's wrong to express an opinion without facts. But since you asked me the question, and I felt maybe I can express opinion because this is my observation. So I'm qualifying it like that, and it's my observation. But I'm sure those from the political party that he markets the lot, they might want to go and check when did he join them and when did he become a member for him to be that active.
So there are interactions between you and him after the 3rd of January leading up to the 6th of July.
We've been talking together up until the press briefing happened. We've been talking. We stopped communicating after the press briefing.
Well, did he say anything further about the letter? Did he say anything further about any of the 3 aspects in the letter, especially the disestablishment? I think that's the word that was used, the disestablishment of the PTKT. Did he say anything about it?
Honorable Chair members, there's been a lot of engagement between me and him in between. There would be conferences, summits, there and there, meetings, BOC. So we come across. There will be a gatherings, the minister is there, he comes with, he's part of the staff, so we talk. That's why you'll see later when I talk about on my statement about the Mr. Mkhwanazi that phoned me in October last year. I phoned Gabinde to ask Gabinde, so he told me about who Mkhwanazi was. I didn't know Mkhwanazi, it's him that told me about Mkhwanazi. So there's been a lot of conversation between me and him. And the last, I think, heart-to-heart talk we had with him, we had at Beachwood Hotel in Johannesburg, and he accompanied me into the car. When they were, I think the tensions were growing already in terms of after this letter, as the team was trying to figure out and the team working out in what they were picking up. And I had an engagement with him there when he said, hey, I don't know anything about what's happening. And I said to him, boss, truth always comes out. So whatever that is happening right now, it's going to come out. So you better be on the right side of the law. I hope you're not going to get caught on the wrong side. That was my conversation with him in Beachwood Hotel. So that was a heart-to-heart talk. Other than that, we'll just meet and greet, hey, how's it? We just talk on the G. And we end there.
And you mentioned that did he appear to know Mkhwanazi well?
No. At that time when I phoned him about a person who had contacted me as Bran Mkhwanazi, he's the one who told me that, no, he's a person who's very close with the minister. But he said he's not working for the department. is not employed in the ministry, but he's close to the ministry.
So he's the person who told you that Mkhwanazi is very close. Is that very close to
that was his word. But that's why I even asked him to give me that Mkhwanazi's number, and he sent me the Mkhwanazi's number to confirm that it's the same person you're talking about.
And is that also, although we were still going to come to it, is that also
senior counsel? Yeah, closer.
Oh, am I? Sorry, Honourable Chair. Sorry, members. Is that also why you alleged on the 6th of the 5th of March, when there was an appearance before it was online, the appearance before the police committee of Parliament of Mr. Cameron, when you alleged that Mkhwanazi was an associate of the minister?
Yeah, that's correct. I was quoting on what I learned from Mr. Nkabinde.
So you got that from Nkabinde?
That's correct.
Did you have any engagement with the minister after the 2nd of January? Did you contact him? Did you phone him? Did you write to him? Did you go to his office to ask him to explain why he issued this directive?
My main concern, Honourable Chair and members, the engagement I will be having with the minister was always work-related, in meetings and so forth, but not specific about the letter. I tried with Nkabinde to meet with the minister so we can talk about the letter, and it did not happen. I tried with the National Commissioner to ask him to secure with a meeting with the minister so we can talk about the letter, and it didn't happen. Until I had to ask the honourable member, Mr. Cameron, to invite me to come to this committee, portfolio committee, so that we can be able to address some of these issues that I'm seeing happening. And yes, we arrived and we spoke about it, but the minister just put a cold shoulder on it. He didn't take it serious. He simply says, no, well, the person that Mkhwanazi is talking about, I don't know the person. So it just ended like that. So those are my efforts. I had actually, even before coming to the portfolio committee, if I'm not mistaken, no, after, I sent the minister WhatsApp directly, where then I was pleading with him that, Minister, can we meet? And it was, I must say, Honourable Chair and Honourable Members, the WhatsApp, I think I will have shared it in my statement.
Yeah, the WhatsApp, General, is NSM6. Honourable Chair and Honourable Members, NSM6 at pages 80 and 81 of the annexures bundle. Which one?
That's correct. Honourable Chair, Honourable Members, this was my effort to try and reach out to the minister as I was observing what was happening up until April. Then I realized that it looks like everyone is failing to secure a meeting with the minister. Let me try on my own.
Can I please? I think this is important. This is a WhatsApp sent to the minister on the 5th of April. Can you have you got it there, General?
Yes, I may.
Can you read it into the record?
Sawubona Minister, that's a Zulu greeting. Please forgive. Yeah, my bad writing there. Please forgive for writing this message directly, but I feel that I must respectfully request a meeting in order to deal with internal issues within our organization which affects me and my family and has a potential of destabilizing our crime-fighting efforts. I tried to reach out through Nkabinde in his private capacity early in January this year. And late, I spoke to him in his capacity as Chief of Staff. And again, I had a special request to the National Commissioner to try and secure the meeting before appearance before the Portfolio Committee on Police. This situation is escalating and it has a potential of demoralizing our hardworking members And there are even politicians that are using these social media posts to sow divisions within the SAPS. I do not like what's happening. Hence, I feel that the minister must call us into a meeting so that we can iron out everything that is dominating the media space. I do not like what's happening. Hence, I feel that the minister must call us into a meeting so that we can iron out, I think that's a repeat of the previous page, iron out what is dominating, everything that is dominating the media space. It is my plea that the minister calls the National Commissioner, Lieutenant General Sbiya, Lieutenant General Khumalo, myself, Major General Khan, Mr. Nkabinde, and Mr. Brown Mohodzi, in order to get to the bottom of the problem. It is the prerogative of the minister to invite the executive director of IPIT if he feels it's necessary. I have requested to take a vacation leave tomorrow and Friday, but I can make time if the minister decides to meet this week. I hope my request will be favorable. And the response from the minister reads, your WhatsApp message was received, will revert at some point.
Did he ever revert at any point?
Not at all. To date, I'm still waiting for the minister to revert to me. In actual fact, Honorable Chair members, there was a meeting that the minister had called between myself and General Sbiya in his residence in Pretoria. And in that meeting, he acknowledged that he owes me for this meeting. He said, I know that I'm supposed to meet with you as per your request, but today I did not invite you for that. I invited you for another meeting. So that was the closest ever he addressed this.
And what was the date of that meeting?
Honorable Chair, I cannot remember exactly the date of the meeting. I don't know if I have it on my statement, but it's a meeting that we held in Pretoria. I cannot remember the date. I'll be lying. Should be in May somewhere, but if I'm not mistaken.
So in relation to the disestablishment of the PKTT, your evidence is that the minister never consulted with you, let alone contacted you or Lieutenant General Khumalo before his decision to disestablish the PKTT on 31 December 2024. And neither did he meet with you, discuss with you, let alone consult you on his decision even after the 31st of December 2024. Does that summarize your evidence?
Yeah, that's what I'm saying, Honorable Chair and members, that in as far as I am concerned, the minister never engaged me. But I've learned later, at the beginning of this year, that there were engagements that the minister, had with both the National Commissioner and General Khumalo. But I was not invited into those meetings.